I beg to mention item number 11. May it please your lordship, I beg to mention item number 11 of daily life.
I am in this case, my lord, for respondent.
Are you
Objection, my lord, provided a date be fixed, my lord.
either adjourn or you do it?
Then, my lord, let the case be.
Lordship, actually, senior counsel ST was supposed to appear, but due to personal inconvenience,
But it's not that one day we'll list, you not do it, again next day we again.
My lord,
Adjournment, we have no difficulty. We can.
otherwise, my lord, this case has been stayed, my lord, our execution proceeding, my lord.
your lordship,
You take a call between you.
offline.
We are ready to adjourn, no difficulty. But we cannot list it within a few days.
My lord,
That depends on the rate. You make an effort. I don't. You can't have the benefit of both things.
for
You
even
choose.
2 weeks, your lordship.
We are keep putting adjourn. Take up with the rate.
Offline.
11.
Namtul.
My lord, otherwise, I will suffer because they have get the stay in the execution proceeding, my lord. That
Then
is
he is object.
Your lordship, kindly see the order. How many agent?
That I can be called. Yes.
May please your lordship, I beg to mention for withdrawal. Withdrawal.
Did you
Withdrawal.
What we
listing or not?
List.
Only get it
List.
listed. Listing, please give the memo.
Now matter is infractuous.
Did you?
Please give the memo. What if you want to read it?
Lordship, I beg to mention item number 6, Lordship. Lordship, I have filed affidavit in
Want
opposition.
adjournment?
No, let's just take the affidavit,
Requisition.
original case
You
record.
call for the affidavit.
Yes.
Item 1 and 2 for admission.
May it please your lord.
Gogo, you were there.
Yes, ma'am. The health department. My lord, there are two petitions for your lordship's consideration.
Why did it before?
Earlier, lordship had
I don't need partner.
not partner.
Yes.
My lord, and there are two petitions for consideration. In the first petition,
Founder Mano.
my lord, the
Who is-
my lord, in the first petition, the petitioner was illegally denied his promotion to the post of associate professor oncology. He
Medical call.
was a medical college. And in the second writ petition, during pendency of the first writ petition, his junior has been promoted by superseding him.
First, you are denied promotion.
Yes.
Second is
His,
superseded.
so if,
And who is the junior?
my lord, the private respondent in the second writ petition,
Who appeared?
Mr. Rajesh Majumdar appears.
Very. Name appeared.
His name.
Send a message to Mr. Modi.
Yes.
That's what he's taking up.
My-
And otherwise, again, he will say that I was not hurt. So, Gogo,
I will try to inform him.
in spite of information, if he doesn't come,
Yes, yes,
it's a different matter. We'll record in an order and get.
my lord. After some time.
Item 3 for orders.
In this case, your lordship was pleased to appoint Mr. Kyle as the
Oh, Mr. Kyle's report.
report.
After some time, my lord, my senior is. Lordship
Mr.
allowed.
Datta also is on legs in court number 5, your lordship. And we have not seen the copy of the report, so the copy needs to be perused to take our stand with regard to.
Let us hear for some time.
Yes.
We'll look at it. Definitely.
Let both the senior councils be
Before
present.
we pass an order, definitely look at this.
Let both the senior council. All right.
Item 4.
Yeah,
My lord, I am appearing because Dr. B. M.
okay, you are in place of Dr. B. M.
My lord, because he is not.
IAS Civil 2023 in RSA 2004 disposed of.
My lord, there are three IA pending. One is, my lord, 3201
3201,
for stay of execution. 3200 is delay condemnation. And one miscase 81 is for readmission of the second appeal,
It was disposed of.
dismissed for default.
Okay, dismissed for default.
So it has 81 is for readmission of the second appeal.
Let us take 81 first.
81 Bala. The order of dismissal is at page 14.
On
One. I am the defendant appellant, concurrent finding. My lord,
we have read the order.
my lord, the first order was passed on
No,
170.
we have read the order. You don't have to.
But-
Now, what is your submission?
Submission, my lord, I have stated in para 9 and
I
10.
think we'll have to issue notice.
One. Because there is a condemnation delay application is also.
One more second. We'll come at a later stage.
Because there was a
Condemnation
delay of filing the readmission for readmission.
Okay, there is a condemnation
Right.
petition in respect of this miscase also.
Mark.
Which is that number?
Page, sorry, my lord, 3200, 3200.
3200, let us issue.
Issue notice. My lord, in the meantime, my lord, only thing because under 151, your lordship is well aware, I did not say. On 8 is the day of execution, my lord. I have annexed that document.
On 8th of
8 November, tomorrow. I have annexed that in
When was 32005.
my lord, page 10. Page 10, my lord. Page 10. 10.
Today, when was it dismissed for default?
My lord, it was dismissed for default on my lord, 28 to 23.
You filed both the application of 17th. Just on the first job.
My lord, only on because we are not aware of and with due respect, my lord, to my friend, my lord.
You are not aware that the vacations are there.
No, my lord.
That is why before
No,
vacation, we
no,
have
you are filing it just 2 days prior to the vacation.
my lord, but
Ensure that the matter is not taken up.
no,
Move it 1 day earlier. Give the pressure to the court that tomorrow is the execution, please stay. Why
I,
should it be?
I'm sorry for that, my lord, but because we got the instructions only on getting the notice. And Mr.
See, if you read the order, see the conduct. This is the
I ad-
third or fourth time dismissed. for
second
the
time,
court.
I admit,
Number
my lord,
one.
only thing this,
Number two, the appellant had not taken steps to get the matter admitted. For how many years?
from 1/7/2004,
For 19 years. For 19 years, you obtained an interim order staying the execution. Number one.
my lord.
Ensure that for the next 19 years, the matter is not even admitted.
Only notice was issued, notice of motion.
Understand? It is not yet admitted. Was it not your responsibility at least to make a mention before the court that kindly see that this kind of an appeal is pending?
My lord, correct, correct.
We
It
are
was,
persuaded.
it was, my lord, with folding hands, my lord,
No,
and
your
pulling the,
holding hand is not sufficient. You are affecting the legal right of the respondents.
correct. My lord, they have also appeared, they have not, they have appeared last occasion, but they have not raised that
They
point.
may appear, they may not appear. That is their discretion. But their non-appearance will not give you
Right, negative right. But only thing because, my lord, Dr. Ahmed is
will stay. What is the subject matter?
subject matter, my lord, we are in possession of a land. We say that we are permissive occupier,
Very well. Where is the land located?
land located in my lord district of Jorhat.
District of Jorhat. Where? In the Jorhat town or village or rural area,
My
commercial
lord.
area? Where? Where is the land located?
My lord, I place it to you. My lord. Land is permissive occupier, to value position. Lands is wooden post bamboo situated in the attached.
Land cannot be bamboo.
No, my lord,
Land
Assam
must be
type,
bamboo. Where is
my
the
lord,
land
defended with a wooden such and such. Jorhat town,
Jorhat town.
block 2, block number 2 of Jorhat
Yes,
town.
Madam Sharma, you must be, Madam Sharma, you must be having some knowledge of Jorhat town. Yes. Where exactly is this land located?
Block number 2, Jorhat town.
It's having some high commercial value or it is having some less commercial value?
Block number 2 would be central, my lord, very central.
Central.
Centrally, Keshav Bora, Mohandra Bora.
What is the likely value of the land? Just approximate.
This is,
approximate.
kiman kotha?
This is sharing 30 feet such and such, dag number 8.
30 feet by 19, 13 to 19 would be 600, roughly 600 square foot. Katha, that would be about 1/4 of a katha, my lord.
Understand. What is the value of the land?
Value would be at least blindfolded, my lord, 25 to 30
Minimum.
lakhs.
Asking the minimum, not the
25 lakhs, my lord.
25.
Blindfolded, my lord.
So if you calculate the rent in respect of a land of 25 lakhs, what will be the rent per year or per month?
Present day around 10,000.
10,000 presently. So it is 19 years. There must be escalation in rent. Let us take it to be the half of 10,000, 5,000. How many months have gone by in 19 years?
My lord,
How many months have gone by in 19 years?
19 into 12, my lord.
How much?
My lord, around
130.
12, 120, 240, around 240 less.
240. 240 into 5,000.
It will be more
Just
than.
240 into 5,000. Yes, Mr. Batra, you were good in
No,
how much? 2,000. 240 into 5,000.
10 lakh.
12 lakhs.
12 lakh.
Well, pay half of it as a cost with state.
My lord.
Pay what was the rent was 12,000. You pay half of it.
My
To
lord,
this
that-
man, to the other side, we are going to stay.
my lord,
Not only stay, we may also recall the order.
my lord, can.
If you don't, it is up to you.
Can
You
I-
take instruction from your client.
My
We'll
lord,
take it up.
after. My
Pay
lord,
5 lakhs cost with stay.
okay.
We cannot allow you to take commercial advantage of the court.
Some consideration, my lord, in and around.
From 12 lakhs, we can drop it down to 5 lakhs. That's the consideration.
Item 5.
Yes, Mr. Sheikh.
I am for the Beatrice. May it please, your lordship. My lord,
Application.
it's a second appeal, my lord. So, my lord,
It will be admitted.
not admitted, my lord. Appeal is not, my lord, here. Appeal was earlier admitted, my lord.
No,
But what happened, my lord? It was
registered as SAO.
SAO.
Then
And
SAO
your lordship directed to register it as
There is a
RSA.
review petition 119 in SAO.
my lord. Yes, sir, order. Yes, review petition order. That review petition was disposed of by your lordship by order dated 16/10/2023.
According to 10 rules on the withdrawal. So SAO was withdrawn. Then review petition, Mr. Dev filed petition, review of the audit. To re-register as second.
My lord.
Yes.
Now your lordship would be pleased to turn to page 48 of my memo of appeal. That is the impugn order, my lord. It starts from page 50, my lord.
This is the order and the appeal.
Yes, my lord.
What is the substantial question?
My lord, my substantial question, my lord, your lordship.
Where you stated in your memorandum of appeal?
Substantial question of law, my lord.
The Sheikh,
My lord.
now this is a RSA.
My lord,
Under
RSA.
Section 100.
Yes, my lord.
Please read section 100.
Yes, my lord.
Read this. 100 subsection 3.
Subsection 3.
Subsection 3 of section 100.
Yes, my lord.
CPC section 100 subsection 3.
My lord. And that will be 3 now. 3, my lord. Subsection 3. Lord, 100 is second appeal, then 3. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal.
So please point out the substantial question of law in the memorandum of appeal.
Right, my lord. Your lordship will turn to page 4 of my memo of appeal, my lord. Page 4 is general point, my lord. Then your lordship will turn to,
Substantial question of law, not the general point.
my lord, next page 5, my lord. First, I have taken, my lord, on objection, my lord, that may be a technical one. That substantial question of law
Out
raises,
of the 7 or 8 grounds, which is your substantial question of law?
your lordship may take 3.
3 arises as to whether lower court wrongly decided the plea of it. This is not a substantial question.
My lord.
What is the substantial question?
Then your lordship will come to 5.
5.
Yes.
Whether the lower abstracted court opinion holding that the ownership of the water were cited in now, where is that finding of the appellate court
My lord. Appellate court.
in the impugned judgment? Where is that
My
finding?
My lord, I am.
That the ownership of the respondent is determined on the basis of an earlier decree.
My lord.
Where is that?
My lord. My lord, page 60, para 20.
Where is it? Just
Para 60, page 60, my lord.
rely on
Para 20.
section 11. No court
Yes. Section 11 CPC has been taken into consideration.
right, it would be- So now they refer to the order in RSA 175 2011,
Yes, my lord.
which is that judgment? Where is that judgment?
My lord, their judgment is not rightly available before your
You
lordship
have to
now.
show it.
My lord,
If you want to argue,
my lord,
you have to show it.
my lord.
Take time, produce.
Who
We'll
can-
examine whether
who can-
the earlier judgment in RSA
My
175
lord, my lord.
creates a bar under section 11 in this.
Yes, my lord.
We'll examine that.
Yes.
But before that, we have to look at the judgment.
Look into this. But
Mr. Abhishek, when counter appellant prays for installment to produce a copy of the judgment
passed in RSA
dated
number 175.
1/11/2011 in RSA 175 2011. I did you call for the record of the opinion certificate?
My lord, the case may come up in the, my lord, admission column. It was wrongly.
Columns are only for.
My lord, I have some urgency, my lord. Let it be
You take your day.
on Friday, my lord.
If you want it today, we can hear it today.
My lord, on Friday, my lord, we will obtain this certificate.
Friday, Parasai.
Friday. Yes, my lord. Obliging, my lord.
Item 6 for hearing.
Sigil করে ফেলি।
Cross strike over.
Yes, item 6. Anything other than adjournment?
May I please, Your Lordship? Lordship, we have received a copy of affidavit in opposition filed in this case number 125 of 2012 yesterday itself.
Next year, 125.
Sir, this is the application under 41 rule 27. Let me show the ground available in the second appeal. Then just
Miss, miss case. Who had filed this miss?
We,
appellant surgeon.
Why have you filed this miss?
for the production of
Who is your senior?
Mr. Espiro.
Are you ready or you are not ready?
Lordship will require a time to file affidavit in
Time may not be
reply.
granted to 11 matters, 12 matters.
We have
Don't
received
expect
the,
that time is readily available.
Lordship, we have received the affidavit in opposition
Because we
yesterday
want to
itself.
understand the matter and then take a call whether time should be granted or it should not.
Lordship may give some time to file affidavit in reply.
I mean, reject it. If you don't come to terms, we reject. Or at least tell us what is the matter about, why there is a requirement to grant adjournment. Tell us
We have
that is based on
received the affidavit in opposition filed by the
that.
respondent
We will
yesterday
put that
itself.
affidavit also. That affidavit may not be required also for our purpose. Not that mechanically we'll adjourn a 2012 matter. Is it admitted
Yes, sir.
Yes.
It's for final hearing.
for final hearing?
Yes.
Then what is this mistake for?
under 41 rule 27,
What is 41 rule 20?
additional evidential.
They want to bring in additional evidence.
Yes, Lordship.
Are you objecting to it?
Yes, Lordship. The case is something different, Lordship. If your Lordship consider 15 to 20 minutes time, I also have written from record itself.
You argue first. Why you want additional evidence?
Lordship,
Then we'll hear him. Then we'll give you time. If necessary.
Lordship, I may be allowed to call my senior after some time.
You are welcome to call. Your senior was sitting here sometime back, 5 minutes back. He was here. Just before the matter was called, he went.
No, he has another matter.
Ask him.
Obliged.
Item 7.
Can we take just few minutes after my see the
Sorry.
we were running short of the juniors because few juniors are follow me, my lord.
You were
Yeah.
sort of junior.
Yes,
We provide you with junior.
my lord. Yes.
Mr. Batra is there to assist.
Yes.
Or you can appoint an amicus also
He has come.
to act as a junior.
He has come. He has come. See the one. Here, my lord, the cases of landlord and tenant, tenants matter. First point, my lord, lordship, kindly, whether if your lordship appreciates my lordship, please come. I'm attacking the appellate judgment matter on order 41 rule 31 CPC. Because in the appellate judgment matter, there was no points.
You appear for the response.
My lord.
There was no point determined. First, there must be determination of points to be decided with the appellate court matter.
Appellate judgment at page 57.
Yes.
Who is the plaintiff? Your clients are the plaintiff.
Tenant, yes.
They are the plaintiff.
Yeah.
Or MIT company is the plaintiff.
Amity company.
Sorry.
Suit for eviction and,
No, MIT company
yes,
is the
my lord.
plaintiff.
yes,
Suit for
eviction and
Irregular
restoration of
super
custody.
irregular.
under the rent control law.
Yes,
Yes, my lord. Urban areas, my lord.
under section 5, madam.
Rent control. Rent control. You rely on the company tax, the earlier one or the old one? Not you, in fact, Mr. Sharma.
Old,
Because you have taken an objection
Yeah.
that Nazrana A. Alam Islam is not the director.
Yes, ma'am, that has
And
been,
therefore, barred under the provisions of Company Act, to
Yes.
file this suit.
Yes.
You rely on section 29.
Yes.
This is
Yes.
the old act.
Old
or the
act,
new
old
old act.
Old act.
That has been handled by the beloved trial court at page 39 and by the appellate court at page 60. My lord,
Some revision, we have to look into every aspect.
my lord. 17 for. Right. I'm afraid. That I don't know.
Yes, Mr. Chaudhary.
Yes. My lord, here first point I have taken is out of 41 rule 31 CPC. The appellate court must frame my lord points for determination,
Order 41.
rule 31.
Rule 31.
Yes. The
Order
Appellate-
41, Rule 31 is content, date and signature of judgment.
the judgment of the appellate court shall be in writing and shall state the points for determination, the decision thereon, the reason for the decision, and where the decision appeal from is reversed or varied. Here it was confirmation of the lower court judgment. So, but in page 60 also I'll come to this judgment, appellate judgment, page 60. Fourth paragraph followed, second paragraph from below. Hence, the judgment passed in suit by the learned trial court is not bad in law and hence not liable to be set aside. The first learned appellate court has concluded that the suit is not bad and it is not liable to be. Then he has gone to discuss other things subsequently.
Yes, Mr. Shah.
Yes.
Continue.
So, my lord, here the judgment is back and the
So what is your ground? That as required under Order 41, Rule 31,
yes,
points of determination had not been stated.
yes,
Is that your ground?
that you are ground.
So why do you say,
Because they also have to go through the entire judgment.
no, we have read it.
Yes. There is points of for
No, I
difference.
took 2 minutes initially to read the judgment. That is already read. Now, that's why I'm asking, why do you
Yes.
say
Well,
points
because
of determination has not been?
the appellate court has not framed the points of determination. Simply, we
No.
discuss. Yes.
Framing of suit and stating the points of determination are not one and the same.
No, I'm not a framing.
Framing of issue is a formal.
No, there is on the trial.
Formal state.
Yes,
Stating the points of determination.
Yes.
What is the interpretation of Order 41, Rule 31? That whether it stating the points of determination
Yes.
must be explicit clear
Yes.
to be stated in a paragraph, or it can be implied from the judgment?
It can be implied also, my lord.
What is the interpretation of 4131?
It can be implied also.
Implied.
Yes.
If it is implied,
Yes. But my lord,
had the point of determination not been stated, if you read it from the beginning,
yes.
this appeal was filed under the ground that the TAP appellant that Nartan is not authorized to file. Then come to page 59. First issue that the response is not authorized and the other way can be discussed under Rule 21.
Yes.
So here stated the points for determination. He has to, appellate court has to determine whether Narzana Islam is authorized to file this suit or not.
Yes.
This is very clearly stated.
Then, my lord, regarding the defaultership and the
Now, your second point. First point, we are not very impressed.
Yes.
Second
Anyway,
point.
the defaultership. Here, the my lord, the method of payment of rent, I would show
So
from.
now you are basically on merit. Whether the
Yeah, now, yes, I am.
appellant is a defaulter or he is not.
Yes,
a defaulter. Yes. Yes. Submit.
Because they have challenged on two grounds, my lord. There is one is defaulter and another bona fide requirement. And so far defaulter is concerned, my lord, that is no, I am not defaulter because the rent was paid as the party will.
Yes, sir.
Party will or wished. There was no fixed time. Yeah, the convenience of the party. Even 2-3 years.
Where is that provision in evidence that the rent can be paid as per
Madam-
the wish of the tenant?
From no, not only from tenant, from the lender also. Sometimes they.
Yes, where is that arrangement between the parties?
You will also will come to first plaint of the.
Where is the material
Yes.
in evidence
Yes.
that it was an arrangement between the parties that the rent can be paid as per your wish
My
whenever
lord,
you feel
from
like?
the plaint itself, it is admitted.
Where is the admission?
My lord, kindly come to plaint.
Right?
Yes.
Plain. Page number. It is admitted in the plain.
Yes, because my lord, if the suit is running, earlier there was another suit, my lord.
No, please show the admission. Definitely taken note of that. Plain starts at page 18. I put.
Yes. Page 18, my lord.
Where is the admission by the plaintiff
Yes.
that the rent can be paid? as
Well,
per convenience?
paragraph 3 onwards, that late Madhusudan Datta came to occupy the suit premises as monthly tenant under the plaintiff as a monthly tenant according to the English calendar month, agreeing to pay the rent the
At the
20
end of each month, very well, at the end of each month.
end of each month.
So it's not that whenever
Yes.
you want to pay. It is at the end
Then
of
my
each
lord come to paragraph 4.
month.
That the late Madhusudan failed to abide by the set terms of paying the monthly rent and was very irregular in payment. That irregular in payment, the Lordship kindly marks irregular in payment of the said monthly rent. In spite of repeated demands by the plaintiff, the plaintiff thereby filed a suit being 120/1963 in the court of the Southern Munship Dibrugarh, claiming for recovery of the possession and area rents of the suit premises. However, the defendant entered into compromise with the plaintiff on 29/11/1966 as per which he agreed to as follows. That the suit be decreed with cost in entirety and the defendant is granted 2 months' time to vacate the suit premises and to pay the decreed rent amount. That if the defendant pays the entire, sum of rupees 958 only, inclusive of rent or compensation up to the end of the month of January 1967 to the plaintiff within 31/1/1967, then the decree will be deemed to have satisfied, and in that case, the defendant will be allowed to continue occupation of the suit premises without vacating the same on fresh arrangement for payment of the rent for premises is the rate of rupees 35 per month.
Mr. Sharma, we
Yes.
read it.
Yes.
Now, what is the
Yes.
submission?
Submission, my lord, then, my lord.
Does paragraph 3 and 4
Yes.
makes it discernible that the rent can be paid at any time on the wish of the tenant?
No, thereafter, after new agreement has come into effect, my lord, in 1967. After the
Not
decree,
new agreement, new arrangement.
new arrangement, anyway. Because he again entered into, he continued to be in position on the new arrangement.
If the tenant pays 958 rupees on or before 31/1/1957,
He paid,
he can continue with the
yes,
tenancy
he paid,
on a fresh arrangement.
yes.
And fresh arrangement is, earlier it was 20 rupees per month, now the fresh arrangement is
35.
35 rupees per month.
In fact, only it is a new,
That-
sort of new agreement.
That does not mean that the other terms and conditions
Yes.
of the tenancy got abrogated.
No.
Or disappeared.
Your lordship must
And
have.
the tenant will pay 35 rupees whenever I feel like.
No,
For
then
the
my
month of January, if I feel like, I'll pay in December. From where do you submit that this was the arrangement between the parties? Contract.
My lord, record has come, I think. In document number 12 and 37, my lord.
On the record.
12 to 37.
You look at.
Yes.
you want the record.
There, my lord, the payment of rent was not regular. It was a convenience solution.
When payment of rent is not regular, that is the legal meaning is the person is a defaulter.
But there was
What do you
no,
mean by-
there was no demand, huh?
Mr. Sharma,
But when because the landlord has accepted without objection.
where is the law that if the landlord does not object, there is a novation of the contract that I will pay the rent at any time I wish?
Because landlord has not filed suit then. It continued for about
Mr.
40,
Mr. Sharma,
yes.
for the month of January, if you pay in June and the landlord accepts it without objection, that means you are not a defaulter for February, January. But for the month of February, if you don't pay within time and the landlord does not accept,
My lord, it
You
was
are
not for
defaulted
1
for
month,
February.
my lord. It was for long 40 years.
100 years will also not make any difference.
Long 40 years, the arrangement continued till 2005 and 6.
These are the most dangerous tenants in the country.
Because
The tenants who continue for 50, 60, 100 years are the most dangerous.
not the matter, because it was between the convenience of the parties, between the parties.
No legal right can be bestowed with
Well,
tenant
anyway.
because I am a tenant for 40 years. You come to term, show us the material, you are not a defaulter. We'll
Yes, on the point, my lord, that payment at the convenience, and if the landlord accepts.
you please produce the material on record which shows that the agreement between the parties was payment of rent on convenience.
No, the agreement by conduct of the parties, my lord, every agreement became abrogated.
No.
Yes, my lord.
Yeah,
Because-
where is that law? Let us.
Yes.
What is that?
My lord, may I cite 1990,
Oh, one.
1983. The 1991 GLR, there is citation of 1983, just the unfairness judgment.
What is the citation?
1991 GLR, page 418.
90 volume 1,
Yes.
GLR,
Book it here.
1990 volume 1, GLR.
Yes.
1990 volume 0 418 on the
418.
Upendranath Paul. That one. Yes, which paragraph?
And paragraph 12, 14.
12, 14 and
And my lord, particularly, my lord, the decision of learned, sorry, Honorable Mr. Hansaria, 1983, last one, Hansaria.
first line is against you.
Yes.
The facts are clear and undisputed. There is no evidence that there was any stipulation to pay rent by a particular.
Yes.
And here is the case, there is a stipulation to pay it by the end of the month.
Yes.
judgment is not applicable.
But my lord, if the lender does not object and the
If the
by
landlord does-
conduct is counting, the conduct of the party.
It's a logic here. I'm giving an example. If for the month of January, rent is not paid in time, paid at a later date, landlord accepts the land without rent without objection, then is a case of landlord accepting it.
Yes.
But for the month of February, if the landlord having accepted in January, for February he does not accept it, then you are a defaulter.
Yes.
Just because it was accepted in January, that does not mean for all time to come you can pay it at any time you get.
No, my lord. It started in 1967 and the shoot was initially 2006. The arrangement continued. In
Your
2006,
tendency of 40 years is also incorrect. This is a tendency of I think 60 or 70 years.
then now it is 6 years, but after the new arrangement came into effect,
1951, my lord.
51.
It's almost nearing 100 years.
Yes.
So they don't want to allow you to celebrate a century.
Because, my lord, we have a big garden of 5,000 biggest, my lord, and
That is.
there are
Big garden and small garden.
no,
is always
not really
becoming
that.
rental.
There are other rooms were vacant, about 7 rooms are still vacant in my. And that is the only place where I
That
live
is
and
their
earn my
decision.
livelihood.
If they want to take it, if they have 10 rooms, they can you can ask them, they can give it.
And
We-
because,
we
my
will
lord,
not stop
we
it.
will not
But we are on the law.
And in this case, my lord, the rent was presented in lump sum in this case.
Okay.
There are some only see the document, they give me 12 to 37.
You're well.
My lord,
It's a right and you are welcome to see the document.
Lord Sakali, go through that document. Sir. That was, no? That was it. Yeah, it is very good.
My lord, the entire case record is before this honorable court. My lord, I've taken certified copies. So his own, that this was dismissed for default twice, my lord. Went back again, my lord, restored for the third time this matter, my lord. Here he says in his cross, we paid rent once for a period of 4-5 years together. This is his own cross examination.
Yes,
Certified copy. my lord.
that is, that's what I am saying.
Well, this had gone back, the entire case record had gone back first in the month of March on 28th. And Malad, it is lying there in the executing court, Malad now. Then again on 22/8, it was dismissed for.
When it was dismissed for default earlier, the record was sent back.
Yes, Malad. Twice it was dismissed, Malad, and then I obtained this
Then
one.
you are executed to follow the record. Because you are you can't deny a litigant from going to the record.
Malad, then in my humble submission would be, Malad, in that case.
Earlier part is of 33 to 82 in immediate reminder to the learned, where it will be in the trial court or the appellate?
In the executing court, my lord, execution is underway.
To the execution court for confirmation of the,
Munsif number 1, Dibrugarh.
you say it to be Munsif number. This one.
If a date may be fixed. Obliged, Lord.
Item 8,
Acknowledgement.
May I please? May I please? Lordship? In this matter, Lordship, we are taking some time, Lordship, because
What do you matter?
Lordship, what happened in this case, Lordship, earlier, Mr. Justice Suwano was there, sorry. Mr. Justice Suwano was there in this case initially. Subsequently,
As a judge or as a lawyer?
as a lawyer, Your Honor.
As a lawyer. That is about 8 years back.
Yes,
So,
Your Honor.
that is, may not be a count.
Lordship. Subsequently,
You pay adjournment cost to the other side. You'll adjourn.
Lordship, what happened in 2 years back,
Whatever it has happened,
Lordship,
this 10-year-old matter, we have no intention to adjourn it. If you want adjournment, pay adjournment.
Lordship, what happened in the last, in the
Or
2008,
if you are,
on 2008,
counsel,
Lordship,
behave yourself. We have
Okay.
expressed some.
Lordship.
If you want adjournment, pay an adjournment cost. If you want to argue, you argue. Third option is not available. Your explanation is also not available.
Obliged.
to you.
Today is so difficult, Lordship, because today is difficult because Lordship,
You pay for your
request-
difficulty. We are not saying we are not accommodated, but you pay for it. It's not free of charge.
Lordship, brief has taken away by the client, Lordship, so we have some.
You don't have hold of him,
Lordship,
then you don't appear. You don't appear, we will dismiss it for the.
Right.
Your client also cannot take the court for a right. Your name,
K. Dekar,
Mr. E. Deca,
K. Lordship, K.
E. Deca, and counsel for the appellant had made a statement that the appellant had taken away the plea.
Okay.
No other counsel has entered appearance for the court to proceed with the matter. When did he take away the?
2 years back, Lordship.
It is stated that the brief was taken away about 2 years back. If that is the case, dismiss for non.
Item 9.
Yes, litigants are also trying to hold the court at a ransom, especially these civil matters. Any interim order for 30 years and second.
Hello, this is a regular first appeal against a decree passed in a money suit. Money suit. A decree of about 48 lakhs. The only ground on which I am challenging this, primarily this decree, if your lordship goes to the
Who's the plaintiff? You are the plaintiff or?
They the plaintiff. I am the defendant. Decree has been
So,
passed.
suit was decree.
Decree. Lordship, may I kindly turn to page 12. Possibly it's a case of remand. That is why I'm pointing out statement. Lordship, in the middle of the page, there are issues that you have seen. Issues. Now, thereafter, my lord, it may be mentioned here that my learned predecessor by order dated 11/9, has the lordship goes the part. 11/9.
The proceeding of the suit in FAN,
Original documents to be produced by the plaintiff, and accordingly on so and so the said suit was reopened. After that, notice were issued to the defendants in order to procure their attendance, but they did not appear in spite of several attempts made by the plaintiff as per provision of
in
law.
what form the attempts were made?
My lord, thereafter possibly.
No, it states,
My lord.
but after that, notice were issued to procure a but did not appear in spite of several attempts made.
Yes.
Where are the notices in the record?
That part was, my lord, adjudicated by the other.
Yeah, by order 9, rule 13, possibly they after attempt was made, the matter came to High Court, some order was passed. Well, I'll just, if your lordship permits me, just complete the second paragraph and come back to that. If your lordship kindly permits. After that notice was issued in order to procure the attendance, this part I am read. Next paragraph. Plaintiff has adduced evidence under order 18, rule 4 CPC, and also produced and exhibited some documents relied upon in support of his case. Plaintiff in his evidence has supported the entire case. The record also reveals that the plaintiff has instituted the suit within the period of limitation, and accordingly, I find a prima facie case in his favor. As such, I am of the opinion that the plaintiff is entitled to a decree as paid. Or my humble submission.
How do you defend that? Pardon, my lord. How do you defend that last paragraph?
Last paragraph, my lord.
Forget about everything. We are not
My
married. Very entitled. How do you defend that last paragraph?
My lord, last paragraph, my lord, of course, my lord, in terms of order 20, rule 5, there must have some issue as discussion.
Let it go back, let it decide.
And my lord, lordship kindly appreciate, it is a case of ex parte decree. And initially, my lord, they made an application on the order 9, rule 13. That was rejected. They failed to.
So, ex parte decree, the appellate court can always entertain an ex parte.
No, my lord. Then they preferred an appeal before this honorable court. And that appeal was dismissed. The MAF. My lord, therefore, my lord, the non-appearance, my lord, they can now.
Mr. Prokestar, where is the law or any proposition of law
my lord,
that because of past conduct,
my lord,
degree can be awarded just because the court is prima facie satisfied? Why? Because that litigant, his past conduct is very bad.
my lord, lordship kindly appreciate, my lord, they have
We
made
are appreciating, Mr.
my lord, they have made explanation in justification of their non-appearance.
Please produce the law.
Yes, thereafter, my
Produce
lord,
the
that
law
was,
that a bad conduct of a litigant,
My
prior
lord.
bad conduct,
my lord. Now, so far as my lord,
can lead to a order against against them without any decision and
lord, if it is my
If you
lord,
say so, Mr. Prokestar.
my lord, my lord. Lord, so far the demand part is concerned,
If
I have
you-
nothing to say,
If you say so,
my lord.
and if you can produce a proposition, we'll be very happy. Why you know? Every writ petition we take up, on the very first day motion, we are going to allow it.
My lord.
Because that's a proposition.
My lord.
Without any reason.
My lord.
We are liking the case of the litigant, we are liking the conduct of the litigant, allow it.
Now, so far as the remand part is concerned, my lord. Of course.
Let us not hear it.
Yes,
Hear the
ma'am.
other matter. You cannot defend this one.
My lordship, I'm not on that.
Then
My lord,
what-
had it been a, my lord, had there been any violation of order 20 rule 5, then it is a case for remand. Therefore, on demand, what would be their, my lord, right to participate in the proceeding?
On demand, their right will be, the court will proceed from the day the judgment was delivered.
My lord. And whatever materials,
Point of time, the judgment was delivered.
my
From
lord.
that point, they will
And
proceed.
they will not have any right to file, to adduce any evidence or to.
We cannot bind them. If they want something, they'll make application, court will decide it as considered.
My lord, in Supreme
Appellate
Court,
cannot restrict anything.
but the Supreme Court says, well, that question was written, my lord, adjudicated by Supreme Court, saying that they have their restricted right.
Please produce the Supreme Court.
Yes. My lord, 2005 1 SCC.
Where is the beginning part of this order?
This order, my lord.
At page 12, 13 that I read.
Yeah.
Beginning part.
Page 10, my lord.
No, that's only the effective order.
Yeah.
The initial part of the order. Which court had passed, who had passed, on which,
My lord, lordship.
when it was heard,
My,
those information.
my lord.
Yes, to which paragraph you are relying?
My lord, had note B. Had note B. May I read, my lord? My lord, can you come to page, my lord, 788? Next page,
Page number.
page number 788. When an ex parte decree is passed,
This is the head note.
yes, no, my lord, discussion.
Where is the main topic? Head note is the editor.
Head note, my lord, there is a discussion, my lord, in latter part of the head note, after head note. Page,
Mr. Purata,
my lord,
these are the editors.
my lord.
Where is the main provision in the judgment by the Supreme?
My lord, page, para 16 and 17.
Mr. Ojumdar, I need just find out what kind of
My-
issues were issued where it was served on.
My lord.
Because he is raising the issue of an ex parte. We have to. Okay. Yes, Mr. Purata, which paragraph?
Paragraph 16, 17. 16, I am reading, my lord. Order 9 rules 7 of the Code of Procedure postulates an application for allowing the defendant to be heard in answer to the suit when an order posting a suit for ex parte hearing was passed. Only in that event, the suit had not been heard, as in a case where hearing of the suit was complete and the court had adjourned the suit for pronouncing judgment. An application under Order 9 Rule 7 would not be maintainable. Next paragraph. It is true that the suit was not directed to be heard ex parte against the respondent to herein, but it remains undisputed that both the respondent filed application for setting aside the ex parte decree before the learned trial court, learned trial judge, preferred an appeal against the judgment, dismissing the same, as also filed a revision application against the order dated so setting aside the suit for ex parte hearing. The said application and the appeal had been dismissed. Even a special petition filed was also dismissed.
Which paragraph you are reading?
17. 17. As withdrawn. In that view of the matter, it is not permissible for the respondent now to contend that it was open to respondent number 2 to re-agitate the matter before the High Court. The contention which has been raised by the respondent number 2 before the High Court in the first appeal, furthermore, was not raised in the said applications under Order 9 Rule 13 of the Code, and even in the miscellaneous petition and the revision application filed in the High Court. Such a question having not been raised, in our opinion, the respondent disentitles themselves from raising said contention yet again before the High Court in the first appeal. Then, my lord, paragraph 19. It is well settled that the principle of adjudicator can be invoked only in separate subsequent proceedings. Then also, they also got attracted in the subsequent stage of same proceeding. Once an order made in course of proceeding becomes final, it would be binding at the subsequent stage of the proceeding.
Yes, Mr. Prokashta, we
Hello.
have read paragraph 16, 17, and 18.
My lord.
What is your submission now?
Now, therefore, my lord, once there is an appeal preferred, an appeal was dismissed. Therefore, question of my lord, having any right to justify the non-appearance, my lord, it will be barred by the adjudicator. Once they fail to justify that they could not appear,
Where they could not appear?
they could not appear, my lord, when notice was served on them. Subsequently, they made an application for vacating the ex parte, my lord, order. That was rejected. They preferred appeal.
The
Court of
no, where is that preferred appeal and order 9 Rule 13? Where is that order?
yes, judgment is there, my lord. Record is
This second flag is the issue note. that national newspaper, has it been exhibited?
My lord,
That national newspaper
my lord.
publication, has it been exhibited?
In fact, that I'm just clarifying, my lord is not coming out with all the facts. In fact, what has happened? We earlier filed an application under Order 9/13 for paying for setting aside of the decree before the trial court. That was rejected. Then we came to this normal court against that.
It's against a trial court.
Yes.
Not the appellate court.
No.
Ah.
So trial court dismissed our petition because Order 9/13
That
says
was an ex parte decree by the trial court.
is this expert degree against this.
Against?
This.
Oh, against this,
Yes.
it's a trial court judgment.
Yeah. So against this, we filed an application under Order 9/13. That was rejected. We came to High Court. High Court also rejected. Now we have filed an appeal on merit.
Okay.
And
okay.
My lord, my
So that
non-friend.
the ex parte thing is the
Yes.
issue is no longer.
So, yeah, that is what I'm saying, man. And your lordship is aware, and there is a judgment also Supreme Court that if Order 9/13 is rejected, appeal on merit is maintainable.
Yes, yes, I'm not.
So if that is there, then why my non-friend is raising all those issues? I'm not.
No, he is raising it for a different issue.
My lord.
Please come to paragraph 17 of the judgment relied upon.
Yes.
That's okay. Preferred appeal against the judgment dismissing the also filed a revision for setting aside the ex parte hearing. The said application appeal has been dismissed. Even special leave has been dismissed and withdrawn. In that view of the matter, it is not permissible for the respondents now to contend that it was open to the respondent to re-agitate the matter before the High Court. Contention has been raised before the High Court in the first appeal, furthermore was not raised in the said application under, and even in the miscellaneous petition, revision application, such a question has not been raised. In our opinion, respondents is entitled themselves from raising the said contention yet again before the High Court. This is regarding the ex parte order.
Yes, that I am not raising, but that I am not at all raising.
So, against the ex parte, you can't raise.
No, I am not
That's
raising.
parasite.
I am not raising. I am not challenging the validity of the decree on the ground that notice was not served on me. That chapter is
You
gone.
are only on merit.
Merit on and
So,
minus.
if it is on merit, and your challenge to the ex parte is gone,
Yes.
then what remains is
Yes.
this is an unreasoned judgment.
Absolutely, man. That is
If
my
we
ground.
interfere on the ground of unreasoned judgment,
Mine.
we send it back
Yes.
for a judgment to be redelivered
Yes. And
based on the material as it existed on the date the judgment was ready.
Yes.
What he is objecting is now the respondent cannot be allowed to bring in more material here and there because the order of ex parte stands. That means you are precluded from bringing in anything further.
My lord, here, as your lordship initially indicated, my lord, we'll file an appeal if
But that will be contrary to your earlier dismissal of the Order 9/13.
Order 9/13
Effect is, moment there is an order for ex parte, the other person is precluded from bringing in any further material before the court. That is what we understand. Ex parte order had not been interfered. It remains. So there is a full stop at that stage
As
for
far as the evidence is concerned.
defendant to bring in any further material. But the court is bound to pass a judgment on the basis of material existing as of that point of time.
After hearing the parties.
Judgment has been delivered. It is before us. We find the judgment is unfit. That's the only reason why you are. So when it goes back, it will go back from that stage that you are precluded further from bringing in any or any further material. You can only at the best raise your argument based on the existing material. You also did, you also.
And that is the view accepted by Supreme Court in another case, my lord. In 1999. My lord, lordship is absolute.
More cases will not make it strong.
My lord, lordship is absolutely right. Supreme Court says he'll be debarred from raising any question, adducing any evidence, even to go for cross-examination.
I'm
the butler appears to be not very happy.
And what I'm saying is, my lord, this point we have not raised yet, do not they can raise because I'm in on appeal.
No, you are on your own appeal, no doubt, but as we are allowing your appeal, we'll also have to clarify it.
Whether fresh materials can be brought in
or we'll not clarify, we'll take note that this is a preceding fact and circumstance of this matter.
That
maybe we'll stop at that.
Minor.
And this is the implication of law in that. Stop at that.
And
Mr. D. Mojumdar and
there are one or two judgments not necessary.
Let us not waste any, but as we are telling, we are not determining anything on merit. Heard Mr. D. Mojumdar and counsel for the petition petition by Mr. R. Patel and counsel also heard Mr. H. Muraka and counsel for the how many respondents? Hello. For the response. The respondent instituted Manisuit 629 of 1996 before the they will just log out.
My lord.
What was the case? 23 lakh. 23 lakh original claim.
40 lakh.
40 lakh. 40 lakh. Raising a claim, money claim of rupees
48
exact figure.
48 lakh 48.88.
With interest.
That figure in page 13 is the right figure.
Page 21 is the claim.
Page 30. 48.
Yes.
Raising a money claim of rupees 48.88. The state money in course of its proceeding was kept in abeyance by the learned trial court by an order dated 11/9/2006 for enabling the plaintiff to procure the receipt of certain original procure certain original documents. And accordingly, by a later order dated 22/1/2008, the suit was reopened. Once the suit was reopened, notices were issued to the defendant for their appearance, for their further appearance in the money suit. The order dated 21/12/2009 reflects that the plaintiffs instituted petition number 4000/09, praying for necessary orders for taking steps under what is that? The order 8, order 8
Substitute serviceman. Order 5.
Taking steps.
Order 5, Rule 9.
Under Order 5, Rule 9 of the CPC, through publication of notice in a national newspaper. By the order dated 22/10/2010, the learned trial court accepted the substituted service of notice by the plaintiff and accordingly proceeded in the matter. Although the appellant defendant, they did not further appear and participate in the proceeding. It is to be taken note that at which stage you filed your order, like Rule 1350?
After the decree was passed.
That original decree 19/5/2010.
Yes. After this.
Accordingly, a decree date, a judgment and decree dated 19/5/2010 was passed, decreeing the money suit in favor of the respondent plaintiff. Being aggrieved and application under Order 9 Rule 13 was instituted by the appellants for recalling of the ex parte decree, for setting aside the ex parte decree. Can I have the details of that?
My lord, this application was filed when the decree was, my lord,
He was,
during the pendency of the execution case.
sorry.
That is not relevant. It has to be after the decree was
No,
filed.
that's why I'm saying.
Yeah.
The Order 9 Rule 13 was passed after decree or during the pendency?
During the
After the
pendency
decree was passed.
Can I have the order? Seven. Seven is some part of DD. 37 is part of the Ah, it is a picture. The RFA is 37. Is paragraph 15 of some PD.
It is there, order is there, defense is 14.
No point in reading as long as I am not having it.
I don't know.
My 37 is different.
And that is mentioned here, the execution case.
But my page 37 is different. It's correct. This is my page 37. It will be so, huh? By the order dated so and so, the application under Order 9 Rule 13 was rejected and being agreed by being agreed and it is being so and so was instituted for the court, for the honorable before the High Court, which again stood by the judgment and order dated.
And this list of dates contains. It will be.
This copy, my.
The third line from bottom. On 6/9/2013, Order 9 petition was filed for setting aside ex parte decree. Then last line, 26/2/2014, plaintiff filed objection against the 26/2/2014, they have filed their objection to our Order 9/2013.
26/2.
Yes, and then 11/6/2014, it was rejected.
Which was by the order dated
11/6/2014. Then we filed an appeal. Appeal was dismissed on.
The both of us is
Sorry.
No, being agreed by the party dated 19. Which was rejected by the order dated 11/6/2014. Being agreed by the rejection of the application of the Order 9 Rule 13, MFA 51/2014 was instituted by the appellant, which again was dismissed.
On 15/10/2014.
Order dated 15/10/2014. Thereupon, but liberty was granted to challenge on that.
Yes.
But however, it is stated that.
And in fact, liberty is not required.
But how? Thereupon, the present appeal being RFA 2315 has been instituted by the applicant, assailing the judgment and decree dated 19/5/2010 on its own merit and not on the ground of it being an ex parte decree. Mr. G. Mojumdar, learned senior counsel for the appellant, has referred to the
Page 12.
The penultimate paragraph of the judgment and decree dated 19/5/2010, which is extracted as below. By referring to the aforementioned conclusion of the learned trial court, it is the submission of Mr. G. Mojumdar, learned senior counsel, that it is apparent on the face of the record that no reason nor any decision had been rendered by the trial court while decreeing the money in favor of the respondent state. A reading of the aforementioned portion of the judgmental or impugned judgment order dated 19/5/2010 also makes it explicit, discernible and explicit that no reason had been rendered, nor any decision, no reason nor any decision had been rendered by the trial court. And it was only the satisfaction of the learned civil judge that the record revealed that the plaintiff had instituted the suit within the period prescribed by limitation, and that the learned civil judge found prima facie case in favor of the petition, without taking any reason as to why he was of the view that he found a prima facie case. Mr. A.K. Purakayastu and counsel for the petitioner, on the other hand, has raised an objection that in the event the judgment and decree dated 19/5/2010 is set aside on the aforesaid reason, it would not be open to the appellant defendants to reopen the money suit once again by producing any further material. For the purpose, Mr. Purakayastu relies upon a pronouncement of the Honorable Supreme Court rendered in Anu Kumar Jain versus Archana Kumar and another, reported in 2005, 13787, wherein in paragraph 17, it has been provided that once an application for setting aside an ex parte order under Order 9, Rule 13 is dismissed, it would not be permissible for the defendant to contend that to reopen the matter once again by adducing further material for evidences as may be thought for. Paragraph 16, 17, and 18 of the judgment rendered by the Honorable Supreme Court in Anu Kumar Jain Supra is practiced. The Honorable Supreme Court, in its supported proposition, is explicit now to arrive at a satisfaction that the ex parte judgment and decree against the appellant defendant that the prayer for setting aside the ex parte have been rejected, and such rejection has been brought to its finality by the order of the Honorable Court in MFA so and so. The appellant would be entitled to assail the judgment and decree only on its own merit and no longer on the ground of it being an ex parte judgment and decree in any manner. On the aspect of the impugned judgment and decree being assailed on its own merit, based upon the grounds as indicated above, that the penalty made paragraph of the judgment makes it explicit that it is not a reasoned judgment, nor any decision has been rendered, comma, it would be appropriate that on the matter being remanded, it would be for the learned trial court to pass a fresh judgment and order on the basis of the materials already on record.
After hearing the arguments.
Comma, of course, after allowing both the appellant and the respondent to raise their, to advance their own arguments as may be advised. In view of the above, the judgment and decree dated so and so in MS number so and so is set aside on the limited ground as indicated above, to the extent that the judgment has neither a reasoned judgment nor any decision has been rendered, and accordingly remanded back to the learned trial court for passing of a fresh judgment based upon the existing materials from the court, by allowing the respective parties to advance their respective.
Some time bond maybe.
As it is noticed that this is the money suit of the year 1996. We request the learned trial court to render the judgment within a period of 2 months from the date.
No, bless. Bless you.
As we have set the time limit for delivery of the judgment, we also require the appellant, defendant, and the respondent plaintiff to enter appearance to the learned trial court.
Yes, that is better.
The records are not there anyway.
Record is here.
The LCR we send back for. Find application.
Yes.
Mr. A. Mr. A.U. Chaudhary, and counsel for the appellant, states that in course of the day, he came to know that the respondent number 9 had died on
26/3/2019.
26/3/2009, and accordingly prayed for adjournment to enable the appellant to file appropriate application. Pray for adjournment. No?
Obliged.
For how long? 2 weeks?
Yes.
Item 11.
In the morning, other side.
Now he's disappeared.
No,
Now he is gone.
No.
Prayed for some adjournment, we did not agree with it.
Actually, I wanted to.
Oh, you objected.
Yes.
What do you do?
No, I'm praying for fixing a date, Milord, so that on that day, because Milord, my anxiety is that that execution proceeding has been.
He is having some difficulties.
Yes, that is there.
The 2022 matter.
20
Very old matter.
No, Milord, this case can be decided at the admission stage itself, Milord.
No, that is
But-
you feel. There is an interim order again.
Yes, Milord.
Did you file any application to vacate?
Milord, because not yet, Milord.
11.
Because in civil proceeding, Milord, this will be decided.
Not be so casual with the slow.
I'm actually.
If you have urgency to vacate, it you file an application with him. That day we will not grant any time.
Milord.
Initially, I did not notice the year of the matter. I thought maybe it's a very old
May
matter. You are
please, Your
requesting
Lordship.
interim.
Otherwise, Milord, this is the anxiety because this honorable court has.
How tell me one person in this world could have anxiety? Everybody has anxiety.
Milord.
Mr. Dotto, he also must be having some anxiety.
Because in all three courts, they have lost, Milord. Now this is the problem.
But right or wrongly, one stay has been granted.
Milord,
If
Milord,
they incorrect stay, file an application. We'll vacate. Adjourn on the prayer of your name, please.
B. Pushilal.
E. Puchilal and counsel for the petition. Your agency file application.
My lord, must.
Item 12 for delivery of order.
Yes. The Chetri, there is a river for vacation between the earlier hearing and today's matter. Very order, what order will I pass? What is the matter?
Matter, my lord, assistant professor Hindi, my lord. And since 2005, she was working against ad hoc non-sanctioned post. Then, my lord, all along in 2013, one sanctioned post arose, my lord, because of expiry of one lady assistant professor, my lord, Hindi.
Last video, 1710.
And subsequently, my lord, that post was advertised. And against that post, my lord,
The record of the selection committee has been produced, which are required to be examined whether the aspect of 50 years of service was given to consideration and secondly whether representation was given. Where are the records?
that one Jagdish Gogoi was there, man.
Pustav Gogoi was the last.
Jagdish Gogoi.
Gogoi.
Where are the records? Is the second paragraph of the order. Understand it, give us the records pertaining to what is reflected. Second paragraph, 40%. Years service experience has to be given its weightage in the selection process. Plus, there is a representation dated something which has to be considered and some order has to be passed. Produce the record which should show that 15 years experience was given considered and that the representation, some order was
proceeding of selection committee, individual marking is statement of principal and consolidate statement carries all are
on the entire thing. Towards the record of the selection committee, which should show that 15 years experience was given it. And plus the order that may have been passed in that.
record that is not available in
the with reference to our earlier order dated 17/10/2023. The response what is the name of the
four respondent number 4 principal of
the authorities and what's the name of the body? The
principal of Sankardev
Sankardev Mahavidyalaya Kothali Pahar Lakhimpur to produce the record of the selection committee for examination of the court as to whether the 15 years of service rendered by the petitioner was given its due consideration in the selection process, and further as to the order that may have been passed on the representation dated 9/10/2019. This one. Produce the official record.
16th.
That will remain as part of matter. Otherwise, yes. My lord, that my lord, otherwise again, my lord.
Order to pardon.
No, my lord, the other, again, my lord, since lordship already heard the matter and taken the.
Item 13 and 14 for admission.
That tea garden matter.
Yes, Lordship, I filed my
You filed your
affidavit.
affidavit.
Yes,
So
Lordship.
when will you go in appear?
Lordship, on Thursday, Friday, or any date, as your Lordship.
So we gave it a liberty to choose your date.
Yes, on Thursday or Friday, on any date.
You'll appear on Thursday or Friday before the exam. With reference to our order of 6/11/2020, the writ petitioners have filed an affidavit stating that they will appear before the state level task scrutiny committee.
Lordship, no copy has been served on either of us. I'm just. Anyway, yes.
On what date you will appear? On what?
On 9 or 10.
On 9/11/2023. In view of such statement of the writ petitioners, the petitioners are directed to appear before the state level consulting committee of the state level. And the committee to proceed in the matter as per law, as per the requirement of law for and determine the factual aspect as to whether the writ petitioners belong to tea garden labor or ex-tea garden labor community, meaning thereby whether any of their forefathers or predecessors were laborers in any of the tea gardens.
Regarding that, Lordship, they will not belong to the tea garden laborer. I have that notification, the new notification.
Okay, they belong to some other community.
Other
But in this school, they are taking admission as tea garden labor.
Yes, Your Lordship.
So this is the question.
Correct, Your Lordship.
This is
If they claim seat on the basis of some other community, other entity,
It's a different matter altogether.
we are not concerned with that
Correct.
in this procedure.
yesterday your participant point regarding that.
Can I need my extra copy?
Point copy.
No, तुम्हारा तो नहीं है क्या? यहाँ तो पढ़ी আছে কি করে মত পড়ে আছে একজন লোকলাই দিন নিতে পারে পড়ি আছে কি বলি লেখা টাকা আমি হাতে মালুকে পড়াই নাই
This is only an advice.
No, the notification.
Yes, lecó, me dijo, ¿no?
Mr. R.M. Das, learned counsel for the respondent in the Social Justice Department of the Government of Assam, has produced a notification dated 23/8/2023 of the Principal Secretary to the Government of Assam in the Social Justice and Empowerment Department, which provides that the community Nunia, thank you for that, has been enlisted as a other backward community in Assam. As per serial number 34 in the list of OBC of we have to understand that the inclusion is prospective from the date of the notification. In the instant case, the writ petitioners rely upon certificate that they belong to the TTL XTGL community, which is enlisted as a OBC for the state of Assam as per the notification of the central government dated 22 at serial number 24. As the claim of the petitioners for admission in the respondent school is on the basis of their certificate that they belong to the TGL or XTGL category. Therefore, upon appearance before the committee would determine as to whether they actually belong to the TGL or XTGL. Meaning thereby as to whether any of their fathers or predecessors did work as a laborer in any of the tea gardens. The other entitlement that a petitioner may claim on the basis of the notification dated 23/8/2023 that the Nonia company had been enlisted as OBC as per serial number 34 in the list of OBC of Assam would relate to a separate legal right of the petitioner, which would come into effect from 23/8/2023 and not prior.
That much. And your lordship may kindly fix a date for the report to be placed before your lordship because.
In
yeah.
date, you will say that
Lordship-
3 months. Same chaos will be created.
That is true, your lordship, but. If perhaps they're all willing to appear on
We are not
time.
providing anything unless after 2 weeks for the report of the committee. You and the committee to determine the matter.
Or your lordship,
strictly as per
fix
you.
it after 4 weeks, your lordship, in case the committee want, because there are several of them. There are about 27 candidates. So after 4 weeks, your lordship, that is also subject to your lordship convenience.
But your
Lordships, the children are studying, lordship, like, I cannot throw them out at this belated stage also, but then another month, at least
what about the others?
Lordships, the 2020 students, your lordship's order of 2020, it remains that in that that interim order has continued and the children have continued to study with us because the state level committee never carried on the exercise. So therefore, I was asking for a date from your lordship because at least as long as this court is in session of the matter, they will at least.
It is taken note, but with Madhuri
Ase Madhuri Patlani, sir.
Does it, that 3 months is the outer limit or 3 months is the
Outer limit.
lower limit?
Outer limit. Outer limit.
So you can do it before that. Okay.
Yes.
But that's not the minimum limit.
That
The
is-
minimum
that-
3 months has to be given.
No.
Lordship, yesterday I had a conversation with the Joint
Hello?
Secretary Social Justice, Lordship. What he has informed me, Lordship, as per Madhuri, if your Lordship passes an order that Social Justice means state level caste scrutiny committee will have to examine and will decide the cases as per law, then they will have to go as per Madhuri Patil, then they will have to.
Let them do anything, let them decide first.
Okay. Then
your questions are only delaying the matter. Do it, whatever you, that's why he said as per law.
Lordship, then it will be go.
And definitely everything will have to be as per.
Then it will be through
No
CID.
court can ask any litigant to do something against it. Ask your respondent to appear that.
Okay. And it will be through
Where is
CID.
that,
Says, Lordship, the inquiry should be completed as expeditiously as possible, preferably by day-to-day proceedings, within such period not exceeding 2 months.
paragraph
Paragraph 9, subparagraph 9, 13, 9.
13.
9.
We have been informed by MS R. Chaudhary and counsel for the respondent school that the school is facing a difficulty in as much as the writ petitioners are allowed to study in the school as per an interim order of the court. But at the same time, a final determination of the rights of the petitioner would depend upon the report that the state level caste scrutiny committee will submit. In this respect, 13,
9, your lordship.
in this respect, the committee to take note of the provisions of the Honorable Supreme Court rendered in Kumari Madhuri Patil versus Commissioner Kudati reported influence at paragraph 13(9), which is extracted as below. And the committee to do the needful by scrupulously by following the proposition laid on by the Supreme Court in the upper extracted. It's clear enough.
It's clear.
Lordship, kindly fix it after 4 weeks. Because a day-to-day
I know.
proceeding, they should be able to do it.
We intend to do it before that. We hope that-
Let them appear.
I think your committee can do it.
Lordship.
Supreme Court is very clear. So it doesn't say that you
No, last
as expeditious.
as expected. Lordship.
So dealing with, you have to give reason why you are delaying. Preferably day to day.
Okay.
What more can the Supreme Court provide? Possibly Supreme Court had taken note of the problem that schools and all may face.
Because from our part, we will hand over the matter to the CID lordship. They will, because yesterday I had the discussion with
But CID cannot interrupt.
Them who is going to.
CID will inquire into the matter.
You can take the help of the police, but you cannot delegate it to the police to do it here.
Okay.
I think there's a provision in that. Madhuri Patil refers to police. Madhuri Patil refers to police also.
Yes.
There are 13.8.
13.8. 38. 38 is notice.
7 and 8 both are given. It starts from 454, constitution of the committee.
If necessary, they can take help of the police. We have been informed by Mr. R.M. Das, Joint Counsel for the Social Justice and Empowerment Department, that the state level caste scrutiny committee had also referred the matter to the CID. In this respect, the respondents are required to take note of the proposition laid down by the Supreme Court in paragraph 13.5 of the judgment in Madhuri Patil, which is again extracted. To make it a criminal case.
Yes.
Only for limited purpose, and the reference to the CID shall be limited to the proposition laid on the Supreme Court, and should not be construed to be a complete criminal investigation. We convert this one. It will continue again. You appear for 15.
Yes, 15 and 13.
14, Mr. Ali.
They have already appeared, those two, there are only two
They have-
petitioners.
Mr. Ali's client
Yes,
have
Mr.
already-
Ali's
Yes,
client,
yes.
he
They-
submitted
they-
yesterday, that they have already appeared.
So let
that-
the committee
so let-
submit a report.
Yes.
On same separate candidate. Report common for people for 30.
The documents are
13 or
23rd.
16 to 18. 13 or 16 to 18. 14 to
13 or 15.
Ask all your
13.
clients to go and appear, get yourself
Yes, yes,
clear.
yes.
If you are tea garden, very well.
Yes.
You come in. If you are not tea garden, make
Yes.
way for the actual tea garden.
Yes.
That's the only.
Yes.
The others are all ancillary complications, nothing.
replay of that.
Time being item 1 and 2.
Where is Mr. Patwari now? He is on leave. I think in the morning he started, but because motion was not there, we.
Related to promotion.
Now what to do? He is there. Yes.
Next week in the
Sure. See whether he is available somewhere near. Number support. On the first call, Mr. J. Patwari, learned counsel for the petitioner, intended to begin the proceeding, but the matter was deferred for the time being. In as far as Mr. R. Mojumdar and the respondent was not present. Now, when the matter is again called, Mr. Mojumdar is present, but Mr. Patwari is
Really
not
is
present
over.
in the court. He is adjourned to be listed again.
I'm being item 3.
Take a convenient date for both, so that next time we can get it.
Order. Report was
Mr. K's report is there.
report.
So your case,
Fully recorded.
while I'm continuing my work, it has so therefore I'll continue.
But
That is your stand.
business was on.
The train was moving, status quo, so train will continue to move. It cannot stop.
Look.
Mr. Take care. On a lighter side. Suppose we understand the order to be that way. Tomorrow you fall sick. You cannot continue your business. If you contempt against you, you cannot stop your.
But it's a natural.
No, understand. You cannot, it's a contempt. Or you don't feel like to going and open your shop one day. It's a contempt. You cannot close early, it will be a contempt. There's a marriage in your house, you cannot close the business. You have to forego marriage, but because of the court order, you continue. Why status quo? Our status quo to be understood in that manner.
Things is as was prevailing at that time.
Understand?
If
understand. Are we to understand it that manner? Otherwise, it will be contempt again. Tomorrow, if Mr. Dotto's client reports that he did not open the shop on this day, understanding the status quo to be having this meeting, it will be contempt on him. Suppose your business is running loss, you cannot close it. You'll have to continue. Suppose your business has become of such a state that every day you are losing 5,000 rupees. You'll have to continue. So are we to understand status quo from that perspective?
To understand, I have to take support of the judgment of the Supreme Court as well as of this court.
Are we to understand that?
In fact, in this case, there was no question as to whether business was going on or not. The injunction prayer was for restraining the defendants from taking possession of the. I was the defendant. I was the defendant. The injunction sought for restraining me from taking possession of the suit land. Now the trial court has found that I am already in possession.
That both the parties to make it still disposal of the land. This is the final order. 1612 is the final order, or is there some interim order?
1612.
Huh?
It's a appeal, appellate order.
No, it's a final order in the appeal.
In the appeal.
Appeal is disposed of.
Appeal is.
What happened? It has to be disposed of within 6 weeks, 6 months.
6 months. But it is continuing.
6 months from 1612. Yes, that means on 16/6 months is over.
Now, my lord, what happened? 1612, this order was passed in the FAO, my lord, by this court. On 17, they filed a petition claiming that I am continuing with my construction of this shop. So therefore, status quo ante as on day 5. Status quo as on 1612 should be maintained. The immediately next day of the judgment, they filed the petition. The court also passed an order, trial court, directing the Najib to go and see and to direct the parties to maintain the status quo. Then he submitted a report that some workers.
This is the reason I often say I'm most disinclined to pass an order of status.
Sir, that is always, my lord. That is.
Look into the matter, pass a clear order this way or that way. The status quo creates all the complications.
If the
you must have noticed my orders. I never pass the order of status quo. Very, very rare circumstance.
This order also, my lord, has to be understood.
Mr. Dotoi, the client is the contempt petition. Or your client is the contempt petition. Your client is the contempt petition. Your allegation is that he is undertaking some construction.
My lord, status quo order was there to be maintained. Now, what they did, my lord, if your lordship look at the bailiff's order report at page 134, that makes the entire thing clear. The trial court asked him to go and see the situation at page 134, my
lord. Yes.
This is by the bailiff of the court.
So, why have you filed this contempt petition? On what allegation?
Now, this order shows, my lord, that there was
They are carrying out some construction.
some construction
Very
work.
well.
There was no shop at all.
So, according to you, this is a prima facie material to show that there is a violation of the code.
My lord.
And why have you filed the IA now?
I, my lord. Well, firstly, my lord, the contempt petition is suppressing the fact that subsequent to the bailiff report, he being dissatisfied with the bailiff report, he filed another petition for a direction to the police to submit a report. The court had ordered that. The police also has submitted a report saying that I did not see any construction.
All these are going on in trial court.
Trial court, my lord. This fact has been concealed in the contempt petition, number 1, my lord. The police has submitted a report that no fresh construction I have seen. A shop business is there. This fact is, my lord, concealed.
By which order trial court required the police to make an inquiry? Can you take a look at it?
Well, page 142. My lord.
Petition of plaintiff means Mr. Dotto's client.
Plaintiff.
Mr. Dotto.
Dotto's client. After the bailiff report, he filed another petition the next day.
The lordship will see the date only.
Page 145, last under the operative part.
And after that,
Well, the police
after that, why is directed to visit the place? After that, what happened?
the police submitted a report at page 153.
153 dated, your lordship will see 22/12.
So now,
Now thereafter, the trial court
This
has
itself
heard
shows-
both the petitions, my lord.
My lord, this order itself shows
that
they have violated.
the court order, done some further construction, and thereafter started operating the shop.
My lord.
This
My
is
lord.
your case.
Yes, ma'am. Because the,
What is the report of Mr. Kher?
my,
My lord, thereafter, both the petitions were taken for final disposal and the trial court had disposed of that petition also.
what it indicates, my
The GST receipts and some customers say that the purchase brought from the shop on 13th.
lord, in that case, bailiff ought to have been examined by the commission.
This is a new.
Yes. So therefore, my lord, in that case, my lord,
No,
I
no,
will,
both things may be possible. Shop is also going on, construction is also going.
lord, that we shall have to see, my lord, that because the
We'll do
bailiff,
one thing. This dispute, let us pass an order. Give continuity operator. Let us be clear and clear. Then not don't remain any scope for. Will not undertake any further construction. And a complete picture of the shop, 360-degree picture of the shop from every angle will be submitted before the London court as of tomorrow or as of day after tomorrow. And that status will be waited till Friday. Plus, trial court had been given 6 months. We'll also put a question why they are executed. Decided.
my lord, I appreciate what has fallen from your lordship. Now, so far, Amin Commissioner report, I have my reservation. My lord, if Amin Commissioner is given such report, then we have a right under Order 26, Rule 10 to cross-examine him under what circumstances he has come to that finding. Because here your lordship kindly see the
He's
bailiff,
not a Amin commissioner.
He's a commissioner.
He's a High Court appointed.
My lord, more or less,
Respectable lawyer who was asked to give.
exactly.
He had given it.
My lord,
Not
commissioners.
the subjected lawyer to now go and get yourself.
No, I'll not say that. I will not say that. At least, my lord, he could have called a bailiff at least. So he was an independent person appointed by the court.
You can call the bailiff and get him examined in view of this report. And Mr. Dotto, we are not interested in this
No, I understand.
violation part anymore.
Yes.
We direct the trial court to complete within 2 months. In the proceeding within 2 months. Originally, court gave 6 months.
Yes.
6 months is over long back.
Right.
We'll give you another 2 months.
Another 2 months.
Complete. And strict order, not the single construction alteration of even your items in the shop you cannot change. So today you are keeping the rod on the left hand side, today, tomorrow you keep it on the right hand side, even that you cannot. Maintain as it is, continue with your business. And the whole thing will be photographed and videographed. And if any change is noticed, that will be considered to be a violation. And completed within 2 months. Let the rights of the parties be determined.
That is true, my lord.
Now, no point in continuing. If we continue on this violation aspect even longer, the ultimate decision will also be different.
Yeah.
Either he will suffer or you will suffer.
It's a very-
We don't know who will suffer.
He won't suffer. I am the suffer. I am the purchaser of the house along the land, and I am continuing my business there.
We are only a contempt. We pass a consequential order. Get it finally determined.
I think so, my.
I think that's the best interest for both the parties.
But then, my lord, your lordship only protect us by saying that because what they are doing, your lordship could understand. Because on
No, therefore I say,
well,
to a court-appointed commissioner person,
yeah,
it will be photographed 360-degree angle. Each and every item, you may take 100 photographs of it, or also video.
Right.
And don't make any order. Suppose today 10 rods are lying here, you can sell 5 of them.
Quantity may increase or decrease.
You bring in more stuff to your shop, you can purchase 5 more and keep it there, make it 15. But the rod from the position where you are kept, it cannot be shifted to another corner of the shop. And not a single item of the shop will be taken.
It's all hardware, hardware
That's
shop.
why I say,
Cement, rod,
Nothing will be changed. And for 2 months. And after 2 months, the interim order will on its own come to an end and the shop will be closed. As parties are trying to take advantage, we allow you to get it determined within 2 months. And if it cannot be determined, the interim order will come to an end.
I have submitted my written statement there, my lord. It is now, my lord, his turn to, my lord, submit the evidences and all these things.
And if they don't cooperate, immediate cost. What is the profit you are earning from the shop every day?
these are all artificial thing made for that purpose.
Whatever it is. If they delay, they'll pay you per day cost. But the shop will not be open.
Shop will not be open
After 2 months.
for their delay, my lord.
For their delay, they'll pay you the per day cost. On the first day after 2 months, you will not open the shop, but they'll suppose you are running at 1,000 rupees, they'll give you in the morning.
If they cooperate within 2 months, it can be.
If he doesn't cooperate, and if you don't cooperate,
I'll not get the money.
You will not get the money, and
shop,
and that will be satisfaction of the trial court, who is not cooperating. Let us be more stringent this time. Nothing left for manipulation. I'm trying to balance both of your either in your favor, not in your favor. You are making a strong case that I have purchased the property and so.
Yes, yes.
So therefore, we are giving you some benefit. And he is a person, he is claiming another kind of a right over that property. Let that right be.
Preemptory right.
Let that right be. He also has a right. Everybody has a at least right to make a claim and a further right to get it determined.
Only on his
Your purchase may be right, he may not have any. Your purchase may be wrong, he may have everything. So what?
That will be decided in the
That will
suit.
be decided.
He has not challenged my sale deed also.
Take it up before the trial.
Yes, my lord, that is already there.
Third, Mr. PG is contempt of people. And Mr.
In this case.
also runs in a counsel for the contempt petitioner, and Mr. PG Saikia ran counsel for the respondent contempt. Respectively, being assisted by Mr. A. Biswas and Mr. R.S. Chaman. Why this FAO 58 was filed against which order?
Against the, my lord, refusal to grant injunction to them, my lord. Against that, they have prepared it.
Who is the plaintiff in this?
Well, they are the plaintiff.
The contempt petitioner instituted title to which? Where is the order in FAO? Which page?
My lord, it is at page 108.
108. The contempt petitioner instituted title suit 166 to 2020 in the court of the learned civil judge Dibrugarh in respect of the suit property, claiming a right of preemption. Claiming a right of preemption. The respondent contender, on the other hand, as defendant, takes the stand that the suit property has been purchased by the in title suit 166 to 2022, Ms. K case 126/2022 had also been instituted by the contempt petitioner plaintiff, seeking for an injunction restraining the respondent containment defendant from utilizing the premises.
No, from taking possession of the
From taking possession of the
premises.
premises. By the order dated 17/11/2022 in Ms. J case 126/2022, what is provided?
Well, the court found that we are in possession, so injunction was denied.
Injunction was refused upon factual satisfaction having arrived that the respondent contempt defendant was in possession of the suit premises. Being aggrieved, FAO 58/2022 was instituted by the contempt petitioner. Like here, we are not adjudicating, we are only mediating. It's basically a mediation what we are doing, nothing. Well, FAO was instituted, which was given a final consideration by the judgment and order dated 16/12/2022, wherein it was provided as expected. Hopefully, it was put it to what do you want to say? This contempt petition is instituted on an allegation that the respondent contender, in spite of the order of status quo dated 16/12/2020, has been undertaking certain construction on the suit premise. And to substantiate the allegation, reliance is placed upon which page it was then?
Well, bailiff report will be at page 134.
134. Upon a report of the process server dated 17/12/2022, wherein he stated that when he had visited the disputed premises, he found some workers who were working inside and outside in an under construction.
Here it is said inside and outside.
In the circumstance, petition number 5619/2022 was filed by the contempt petitioner under section 151 of the CPC. Would it fair for a direction to the officer in charge of Dibrugarh Police Station to implement the order of status quo ante as on 16/12/2022? Passed in FAO. The Learned trial court, while considering the petition dated 5/6/19/2022, by its order dated 19/12/2022, who had report given this? The report is received today. Who gave this report?
That police report.
Uh, Considered a police report dated 19/12/2020, which provided that the process server had captured certain photographs and videos of the under constructed shop from both inside and outside, and further that the husband of the Sanjay Agarwal,
His husband of
Defendant's husband.
of the respondent
defendant.
contemnant, that the husband of the respondent contemnant, namely Sanjay Agarwal, had given a reply that he was working on his own property.
Well, this was with regard to bailiff report.
He was working on his own property. Whatever recorded, we have not added anything.
This is not on the basis of police report.
This
my
is
lord.
on the basis of bailiff report.
So it's quoted in the order. That's why I asked you whose report is it. However, report is received today.
This is the report of the bailiff.
Report of the bailiff. Accordingly, by the order dated 19/12/2022, the learned trial court deemed it appropriate that it was a fit case for taking police assistance to execute the order of the status quo dated 6 of the High Court, order status quo of the High Court dated 16/12/2022. The a sub-inspector of police of Milan Nagar Police Outpost submitted a report dated 22/12/2022 before the Learned Trial Court, wherein it is provided that when he had locally visited the disputed premises, he had found that no further construction was done, but the opposite party had opened a hardware shop after repairing the front side of the shop. In the contempt proceeding, it is the stand of Mr. S.K. as Dr. Learned Senior Counsel for the contempt petition that having undertaken the construction after the order of status quo, the respondent contender had willfully and deliberately violated the order of the court. Whereas on the other hand, it is the stand of Mr. P.J. Saikia, Learned Senior Counsel for the respondent contender, that he had all along been operating his shop and he had not undertaken any further construction in the shop premises. And relies upon the report of the Sub-Inspector of Police dated 22/12/2022 that he had undertaken certain repairing work in the front side of the shop. This is your report. Based on the aforesaid stand of Mr. P.J. Saikia, Learned Senior Counsel, respondent contempt, Mr. Dr. Learned Senior Counsel had urged upon that as on 16/12/2022, when the order of status quo was passed, no business was being carried out by the respondent contempt. And therefore, even the act of conducting of the business was a violation of the order of the status quo. In this circumstance, we requested Mr. S.T.K. Learned Counsel and the Learned Counsel to make a local inquiry and submit a report as to whether, as on 16/12/2022, the respondent container was operating any business activity in the disputed premise. The report of the learned counsel, Mr. S.T. Care, dated 16/10/2023, reveals that certain GST return of December 2022 corroborated certain statements of some of the customers of the shop of the respondent container that they had purchased some items as on 12/12/2022 and 13/12/2022. And based upon such material, a report has been submitted that it has to be understood that as on 16/12/2022, the respondent container was operating a business in some form or the other. In view of the materials above, we have to understand that we have to understand the order of status quo that is 16/12/2022, that as on the state date, some business, the business in some form was being carried out by the respondent container as on the date when this order status quo was passed. But at the same time, it cannot be expected that the respondent container would undertake any further construction work over the suit premise. Accordingly, as a consequential relief in a contempt petition, we modified the earlier order of status quo dated 16/12/2022 to the extent that from the date of the present order, that is 7/12/2022, no construction, modification, renovation, or alteration in any form of the disputed properties would be carried on by the respondent or containers in any form would be carried forward by the respondent containers. But at the same time, as some business was being carried out, the respondent containers are permitted to carry on the business in the manner they were conducting without any further expansion without any further alteration of the nature of the business that is already being carried on. Expansion, again, if you want to sell 20 rods, you cannot prevent it. Suppose today he says he is customer for 10 rods, tomorrow he finds his demand is more. You prevent from selling 20 rods. But you from rod you cannot go to something else.
Yes, yes. Hardware materials. Whatever is there.
We also take note that the order of status quo dated 16/12/2022, which is alleged to have been willfully and deliberately violated, had imposed a time limit of 6 months for the actual dispute to be decided in that way. And we have also taken note that the time limit of 6 months that has been fixed has already elapsed by more than 5 months. In this circumstance, the order dated 16/12/2022 is further modified to the extent that the entire proceeding shall invariably be completed within 2 months from the date of the present order, that is 7/12/2022. 7/11/2022. if there is a delay in completing the proceeding because of any act or omission on the part of the respondent contemner, the order of status quo, as modified by the present order, shall not operate any further on and from the completion of the 2 months from the date of the present order. And the responding contemner is directed not to operate any activity, including business activity, from the disputed premise. On the other hand, if any delay is caused because of any act or omission on the part of the contempt petitioner, for every day of such delay that may be caused, the contempt petitioner shall compensate the respondent contemner in monetary terms, commensurating with the business activity that was being carried out. And but with a further condition that upon receiving the daily compensation, the disputed premises shall not be used for any purpose. Just every morning you don't open the shop, you take the money. Otherwise, this will go on. Because whosoever has the advantage will drag it longer.
2 months from today, maybe lesser because the evidence they have to late. Then
if it completes earlier,
from the date of
the London Trial Court is always at its own discretion to complete the proceeding on any day prior to the completion of the meaning thereby that the 2 months is to be considered to be outer limit.
Yes.
And
two working months, excluding the.
What I submit, both.
Otherwise,
somebody will say on that day it was a restricted holiday, another party will say no, it was.
Then it's okay, my lord.
So ultimately it is.
What I submit, both the parties will appear before the court on a particular day, and these 2 months should commence from that day.
Petitioner as well as responding conference shall appear before the London Trial Court on.
No, I think, my lord, the proceeding is going on. Date is already fixed by the trial court.
No, but now new direction.
That your lord.
On Friday.
Right.
Friday. And the London Trial Court shall make an endeavor to complete the proceeding
within the time frame. That's all. But I'm not happy with the report of the commission.
Again, it will prolong the.
No, that part is okay, my lord. But then,
that is why
but then way he has decided, it's really.
The next time the same person is by you, make an objection.
Definitely, Melody. This name comes to me.
What else can
Yes.
I can understand. But again, that will need another set of evidence. Ultimately, the main issue will be sideline.
I understand, my lord. Yes, I understand.
So no one will gain, gain out of it.
Because if we
are reported, although we have acted upon the report, we are clarifying that we take note of the objection of Mr. S. Dr. Senior Counsel that the contempt petitioner is not satisfied with the report.
But why I'm saying so?
But at the same time, the parties shall not raise the said issue before the trial court.
No. Because in that case, it will be delayed.
It will be prolonged. So as to avoid the possibility of the litigation being prolonged any further. Yes, Mr. Something left.
Lord, he wanted to say something. Yes.
What do you want?
Means the report, my only suggestion to my senior was that an observation that this commission report may not be used as an evidence before the trial court.
And it is further provided, a commission report shall not be used as a material on evidence by the trial court.
Rightly pointed out.
In my WS, I have said on 21/11/22, I have started my business.
You prove it separate, not on the basis of
that I have
that
to
would be a
prove.
transport.
Online every little late. You file an application with record. Item number 8 is that somebody the brief had taken away. That
Yes, yes, Lord.
if you 2 years back somebody takes away the brief, does not bother to appoint a lawyer, matter of I don't know how many years old. What else can we do? That's the only way to compel the litigant to come before the court. We'll dismiss, you'll get it restored. We'll at least have a lawyer before the court. Then you are. Otherwise, the other step would be requiring the registry to issue notice to that. That will take another 2 years. You wait so much.
Item 4.
You are the person who said brief taken. Then why are you bothered?
I think at least one opportunity.
Responsible.
One opportunity may be.
So why should you plead on behalf of somebody who had taken away the brief from? So even if it is not signed and the dispute arises whether taken or not, we believe the lawyer more than the.
But similar matter was there, so they've taken away our file.
So what is the lawyer? Lawyer is a power of attorney holder on behalf of the litigant. Wakalatama, civil language. It's the language of a power of attorney. So once the power has been withdrawn from you,
Online.
My lord, as regards your lordship query, I have through my friend, I have conveyed those regarding that stay. My lord, they need some discussion among the family members for that 5 lakhs of rupees. Can it come next week, my lord?
The frame, your lordship, for the
Next week.
Because otherwise,
my lord, I understand. I understand. My lord, it is the part on our part should have been taken into consideration that.
Otherwise, you are enjoying property, which may be yours, may not be yours.
I admit everything on your part, your lordship.
So therefore, whatever is the actual benefit you have taken, we have
should be compensated.
Made it less than 50%.
Should be compensated. At least the rent, like acquisition and requisition rent, my lord.
Otherwise, here the
otherwise
undue enrichment of a property.
Definitely, my lord. I admit.
And regarding your case on merit is something different.
But for 19 years without an admission, I admit, my lord, I definitely bow down my head before your lordship.
You remember some time back, it was commercial court.
My lord. Correct.
Money. Huge amount.
Huge amount.
Some hundreds of crores. The defendant is not filing a written statement. Once the written statement is not filed, when precluded, it comes before the court on how to compare. One,
at least some cost to be imposed.
One is you have an inherent legal right to oppose the claim against you by filing written statement. Other one, by not doing so, by deferring by every day, you are gaining
an unjust enrichment.
At least the interest component of a huge amount of hundreds of crores. And see the amount of interest it will come. Everybody will do it.
My friend has conveyed them. Only thing, my lord, they are the weaker section financially, so they have to collect.
Or then you can pay it in installment.
Or at least.
But something has to be.
No, definitely. Obliged.
So in that commercial matter, what we did, we took out the approximate amount of financial gain you are having every day. The number of days you have delayed in filing. Pay that amount and go and file.
Correct. That is the cost.
So that in future you don't.
CPC also provides that.
So that in future you don't do it. Delay and take advantage.
Correct. I take you.
Item 4.
Item 6.
Yes, madam.
May I please, your lordship?
Matter to be adjourned.
Matter be passed over for the time being.
Time.
Yes, sir.
Is the last.
What is the meaning of the word time?
My
No, what
seat-
is the meaning of the word time being?
timing means, your lordship, little bit later.
No. The dictionary meaning of both the words is different. Time being and later. Later is after some time.
Is a after time.
Time being is what is
May I place them at around Thursday?
some other matters are in queue of something. But it is still again in the 2012 match.
Your lordship, affidavit in opposition has been filed yesterday.
Let it be fine. How does it matter?
And it's not in the record.
Does it matter?
Take all. Take.
Don't come out with this. Sorry. Because we have noticed your senior. Whenever the matter is about to be called, he is here. Before. And when it is about to be called, he very casually he goes out and says, I am busy somewhere. Once the matter is adjourned for time being, again he appeared. Pay adjournment for. The civil matters are piling up like anything. Why? Because no one is ready to do it. There is no concept in the judicial proceeding that if the civil matter, it should take 100 years to decide. Nothing like that. And always the young lawyer is sent to the court that you pay the fine. Ask him to come. Ask the senior to come. Or we self-guided meeting. Somebody must be following the proceeding from outside home. One person just not 15 and say somebody something in the mobile. Very. Somebody is keeping what the court is doing, passing on the message. These are 30-year-old strategies. Nowadays, we are in 2023. Court proceedings are little different. Okay. How to say it? Last item. If it doesn't come within 1 or 2 weeks, wait a minute. Course cannot be tolerated.
Otherwise, they don't have any good case here.
That is apparent.
Yeah. Your Lordship, my name is Aspiro in Lake Court number 70. He's coming under 15 minutes, Your Lordship.
15 minutes.
Lordship, it might. Just for, Lordship, for time being.
No, timing is over. We given it one. Second time, no.
There are two matters there in court number
Doesn't
70.
matter.
Consecutively, Your Lordship. So one matter got over, but other matter.
Maybe any. We are dismissing it.
I'll call him in right now.
Call him immediately. And you are a civil lawyer.
Yes, I'm.
You are a civil. You practice in civil court.
Yes, Your Lordship.
Are you aware of the provisions of the CPC
Not so much, Your Lordship.
regarding
Learning,
enrollment? Are
Lordship.
you aware of the provision?
Regarding what, Your Lordship, exactly?
What regarding what?
I'm.
Read the order 17 rule 2. See. Take a CPC and read it.
Second. 17. Order
17 to please read it now. For your
Cost of adjournment in every such case, the
no,
court.
read 72C, not the whole.
The fact that the pleader of a party is engaged in another court shall not be a ground for adjournment, Lord.
You are asking something contrary to the CPC.
Lord, just for me for time. I'm calling immediately. He'll come.
We have waited enough. Since sitting in the court in the second half, this is the only matter we have taken. 20 minutes have gone by.
Just a couple of
And
minutes.
enough
Lordship,
is enough. Go and tell your secret. And repeatedly, he is coming to the court when the matter is not taken. And when the matter is called, he simply disappears. I'll call immediately. And stop this playing this game. What is the matter regarding some land?
Yes, Your Lordship. They preferred this, sir, seeking a declaration in respect of one katha, one lesser land, and ejectment of the
Where
defendant.
is it located?
Yeah.
Where is the land located?
Here, near cycle factory. Near cycle factory.
What?
Guwahati.
One katha land.
One katha, one lesser of land.
Land. They are the plaintiff or they are the defendant?
They are the plaintiff, Your Honor.
Plaintiff. What is, where is the place?
Lordship will find land at page 25. Schedule, subject matter, Your Lordship will find at page 8, Schedule A property. And they sought for ejectment of the defendant from Schedule B property. Whereas the land of the defendant and the land of the plaintiff is completely different. Sorry, my lord, I was on leg.
Like you adjourned in 2005.
Lordship, my learned friend yesterday filed affidavit in
No, then you
opposition.
filed. We are on the AP.
No, I want to point out that
We have already been pointed out number of occasions.
that is not on record.
May
That
not be. We
Oh,
take, that
already-
is
already
we-
there.
we- you argue.
Yes. May I appeal, Lord? Lordship, the petitioner is a plaintiff. File a title suit, Lordship, for declaration of right title interest.
Peculiar plot of land, that this land was originally, owner was Fakhruddin Ali Ahmed. Family arrangement, it came to the brother of Fakhruddin Ali Ahmed. And the brother, by a registered sale deed, sold it to the grandfather of the present plaintiff.
Yes, yes.
And you want the declaration of right title and interest over the scheduled land and recovery of possession. How did you lose the possession?
Lordship,
In what manner the plaintiff had lost the possession? Because
lost position, Lordship,
your
the,
statement is and handed over actual possession.
yes.
Para 4. Then how did you lose the possession?
Lordship, the defendant of the suit, Lordship, they forcibly and illegally occupied the land, which is described in the schedule of the plaintiff. So, Lordship, please to
suit
take
was,
up,
dismissed.
Lordship.
On what ground?
Lordship, what happened? I had given all my title documents, sale deed, Lordship, patta, Lordship, and all other title deeds, Lordship. The learned, the counsel who was conducting the title suit, Lordship, he did not file the Jamabandi, Lordship, the sale deed, or the Lordship patta.
Have you lodged a complaint to the bar council?
No complaint has been. We the labor.
Otherwise, how can he take?
Lordship, the appellant is a laborer, Lordship, daily wage earner, Lordship. He is not to.
In affidavit, they mentioned, Your Honor, there is businessman.
But he is a litigant who can engage Mr. SP.
Oh, Lordship,
Maybe but he can
Lordship, I am also a social worker. Many cases I conduct, Lordship, without
That is
taking
okay,
any.
we are not on that. Now, which document you have handed over to the lawyer but not filed?
Yes,
Can
I have
take
a,
look
yeah,
at those documents?
your Lordship, yes, Lordship, I have filed an application under order 41, Lordship, rule
Under order
27.
41,
For giving additional evidence. There I have discussed.
the order 40,
For giving additional evidence.
41, rule 31,
27.
27.
Your Lordship, please to take up MC 125. Some order to full na detail photo ko into section full order 41 ula na. Easy to me practice button.
Where these documents earlier placed before either the trial court or the cross appellate?
Not at all. No, Lordship, it was not filed.
It was not filed.
It was not filed, Lordship.
And where is your mistake?
Mistake, Lordship.
125.
Yes, 125.
Actually, their case is something different here.
We'll hear you.
Alright.
Why do you disturb
Why
me,
you are-
Mr. Roy? We'll take you. We'll hear you. Where is your evidence?
Lordship, may come to page 3 of the this case. That the petitioner's appellant plaintiff is an illiterate daily wage earner, labor, and somehow know to put his signature only in the examiner's receipt and totally ignorant about the legal proceeding and the steps to be taken in a suit, and was completely banking on the advice of his learned counsel before the court's below. That the settlement operation of the Beltala Moja was concluded on 31st/12/2009, and KP Patta number so DAG number so was issued by this so in the last week of December 2009 of DAG number 174 was issued by the SO in the last week of December 2000, and in the said Patta the name of Durbali Rajbari is clearly showed as Patta number 16 Lordship. Durvali was the father of the present appellant. That the witnesses of both the parties were concluded by the learned trial court on 5/10, and the suit was fixed for DI in 2007. And in 2007, the patta was not issued in the name of the petitioner plaintiff or his father. But the issue has granted certificate dated 29/3/2008 in respect of the land measuring 2.81 R by assigning new patta number so and so and dag number so and so of village Patasil Moja Beltola in the name of father of the plaintiff. Next page, Lordship, para 6, that the learned counsel of the petitioner's appellant plaintiff, Mr. Nausad Alam, who had conducted the suit before the learned trial court, had not instructed the petitioner plaintiff to obtain the certified copy of the Jamabandi or to call the Lord Mandal as a witness of the petitioner plaintiff.
Where is your reply to this?
I have filed a reply that has been tagged, Your Honor.
Can I take a look at?
Yes, yes.
May I read further?
I've completed. Whatever you want to read, I have already read it.
क्या अभी जो सर्टिफिकेट ऑफ प्रोसेसिंग वो दिया है क्या कहता है ये दिया है कल फाइल किया तो वो दिया है हाँ अच्छा
You read paragraph 6 of your application.
Yes, I have only. That part, 4 copy has already been taken.
Yeah, I am giving it. You read.
You did. Get a party. Give me 30. Hurry. Hurry. Get party. Yes, you read paragraph 6.
With regards to the statement made in paragraph 4, 5, 6, 7, 8, 9 of the application, it is stated that those statements made by the appellant are beyond the plan. It is stated that the appellant had preferred original title suit bearing title suit number 76 of 2006 before the court of Munsif number 2, Kamrup Metro at Guwahati in the year 2006, which was dismissed by judgment and decree dated 8/3/2010. Thereafter, the appellant side preferred appeal challenging state judgment and decree dated 8/3/2010, which was registered as title appeal number 45/2010 before the court of civil judge number 3, Kamrup Metro at Guwahati. Accordingly, the learned first appellate court, after hearing both the parties, by judgment and decree dated 6/8/2011, dismissed said title appeal number 45 of 2010. It is respectfully submitted that both the appellant and defendant relied certain documents in original title suit number 76 of 2006 before the court of Munsif number 2, Kamrup Metro at Guwahati. And thereafter, both the parties also lead their respective evidence before the learned trial court to prove their case. And accordingly, the learned trial court, after hearing both the parties, considering all materials, disposed of the case. Thereafter, the learned first appellate court, being a last court of facts, also considered all materials available in the case record, and thereby, by judgment and decree dated 6/8/2010, dismissed the appeal. Now, after failure in both suit and first appeal, the appellant side with a malafide intention trying to mislead this honorable court only to fill up lacuna in this case.
Now you read paragraph 6, 7, and 8 of the
Yeah, if Your Honor allow me
read
to.
paragraph 6, 7, and 8 of the mistake.
My pleasure. That the learned counsel for the petitioner appellant, plaintiff Mr. Nausad Alam, who had conducted the suit before the learned trial court, had not instructed the petitioner plaintiff to obtain certified copy of the Jamamande or to call Lakmandal as a witness in the petitioner's plaintiff with Jamamande record, and due to bona fide mistake on the part of the learned counsel of the petitioner plaintiff, the Jamamande could not file and exhibited, and for fault of the advocate, the petitioner appellant plaintiff should not suffer, and petitioner appellant plaintiff raised before your lordship to allow petitioner appellant plaintiff to adduce evidence under order 41 rule 27 of the CPC for doing substantial justice, as because the petitioner appellant is the real owner of Schedule A dispute land, and the impugned judgment and decree has taken away the vested and concluded right of the petitioner plaintiff appellant. 7. Being aggrieved by the judgment and decree passed by the learned trial court dated 8/3/2010, the petitioner plaintiff had preferred title appeal 45 of 2010 in the Court of Civil Judge number 3 Kamrup. But as the ill luck would have been before the appellate court also, the learned senior counsel of the petitioner appellant, Mr. B.K. Sam, never advised the petitioner appellant plaintiff for giving additional evidence to prove the Jamabandi mutation certificate and patta as stated above, and the petitioner plaintiff become the victim of the false negligence of the learned counsel. 8 number paragraph. The petitioner appellant is ignorant about legal proceeding and the provision of law, and he had suffered substantial loss and injury, denied justice to the appellant due to negligence of the learned counsel of the petitioner appellant before the court below, and due to said reasons of the appeal, petitioner appellant was dismissed by the learned first appellate court by judgment dated 6/8/2010. Actually,
Now, Mr. Your name, please.
R. Ali.
Mr. Ali. Make one submission. In the this case, it is a specific stand of the appellant petition.
Yes.
That they are in possession of some document, like Jamabandi, etc., to establish their title over the land. But even the name of the learned counsel is given. The learned counsel is not properly advised. And he also says that he is an illiterate person, does not know. So he is wholly dependent on the legal advice of a lawyer. His stand is he had could not find for the fault of the advocate because the advocate had not said that to establish a title we need a job. Same thing happened in the first appellate court. If you read paragraph 8, it is only paragraph 9, it is only Mr. S.P. Roy, when he took up the brief for second appeal, he had given this advice. And this case is filed immediately in the along with the appeal itself in the year 2012.
After 11 years, Lordship,
Now, you have taken 11 years to give a reply to this one, number one. Number two, you have not denied it. You have only given your argument that this court was passed a judgment, this judgment, appellate judgment, everything. You have just described the history of this litigation, but you have not denied the specific fact. So, in terms of your affidavit, although 11 years later, under the law, we have to understand that by the principle of non-traversal, it is they had the document with them, but could not produce it because of the reason stated. And this is an admitted position. Now, if this is an admitted position, that the learned counsel in the trial court did not ask, learned counsel in the first appellate court did not ask, learned counsel in the second appellate court immediately notices this huge lacuna and filed an application under Order 40. Now you read Order 41 Rule 27.
That's true, Your Honor. I admit that part.
If
Your
it
Honor,
is true,
first,
this is a matter to go back.
Your Honor knows very well about the various judgment of Supreme Court as well as
We
our
don't
High
know
Court also.
We don't know anything.
Yes, Your Honor,
Raji.
appeal, Order 41, Rule 27 is to
Mr. Raji
consider
cannot-
about with the merit of the appeal, Your Honor. Order 41, Rule 27 is to consider with the merit of the appeal, Your Honor.
Why do you say?
So if Your Honor allow me to go through the plant as well as their
No,
case,
sorry,
their case is completely different than the,
Mr. Ali, we understand. When a document is not produced,
that document is even not necessary for proper adjudication of the matter. I will say everything from record itself. If
you
Your
may
Honor
submit
consider,
anything, Mr. Ali, we are not hearing this appeal on the merit of the second appeal. For the time being. For the time being, we are hearing this appeal in respect of the application under Order 41, Rule 20. So you have to segregate the two issues.
you know, there
It
is
will
some.
not allow you to, for the time being, to submit on the merit of the second, because he is yet to start. We are precisely hearing the statements in paragraph 6, 7, 8, and 9 of the mistake. The application under Order 41 Rule 27, and this we will hear.
That cannot decide independently, if Your Honor.
Mr.
Allow me
Counsel,
to.
your smile will not make you. Where is the law?
Yes, Your Honor, there are various judgments. Order 27, Order
Your-
27 cannot
your-
decide independently
Your
without.
statement, various judgment has no bearing on it unless you produce the judgment.
Yes, Your
That
Honor.
this is the judgment I want to rely on. These broad statements anybody can make. There are thousands of judgments on this. No effect on it.
Various judgment in.
Produce at least
Cannot.
one. That this is a fit case where Order 41 Rule 27 should not be exercised. You are keep it confined to that for the time.
If Your Honor allow me to go through leading kindly, Your Honor.
It's not allowed because we are deciding only an application under 4127. An application of 4127 is unrelated with the plain, it is unrelated with the written statement, it is unrelated with the judgment that may have been passed.
Hello.
If we reject this application first, then we will hear you on the merit of the second. We'll hear you everything what you are trying.
Your Honor, this is judgment.
Show us one judgment that in the facts of this present pleading, 4127 is not applicable.
Page 5, Your Honor. Okay. Page 5, paragraph 11.
Today, some
Page 5, paragraph 11.
paragraph,
11.
which paragraph?
Paragraph 11, Your Honor.
Paragraph 11.
11. If any petition is filed under Order 41 Rule 27 is an appeal, it is incumbent on the part of the appellate court to consider at the time of hearing the appeal on merit, so as to find out whether the document or evidence sought to be adduced have relevant or bearing the issue involved. That has to satisfy first by the appellant side. Why that particular document is necessary for proper adjudication of the
We are
case.
giving you that. That answer we are giving you straight away. Come to the plane. the type copy starts from page number
23, 5 Lordship, Annexure 2.
read para 4.
Yes, Your Honor. Yes, Your Honor. But Your Honor, in paragraph 5, they admitted their property and Assam type was assessed under holding number 427. But we are possessing house under holding GMC number 428.
We are not interested in that.
Kindly peruse my written statement.
Mr. Enthusiasm test,
yeah,
exuberance test, logical presentation, the better way. Look at this statement.
Yes, Your Honor. That is true, Your Honor.
That Durbali Rajbar had purchased land from Asamuddin Ali Ahmed by registered sale deed number so
yes,
in respect of Schedule A land. Do you mean to say that the schedule of the land of the in dispute and schedule of the land of Schedule A of the sale deed are different lands?
yes, Your Honor.
They're different.
That is my
Please show it.
yes. Kindly peruse my written statement.
We will not pay you written statement. Show it. Show the sale deed and show your schedule of the dispute.
Yes, kindly peruse my annexure. Annexure. That is exhibited document, Your Honor. Your Lordship will
And where is the sale deed number 180081?
This is their salary, Your Honor.
Page number. Page number. Sale deed 1800 of 81.
We have not denied their salary.
They have not denied, there is no counterclaim by the defendant. Sale deed will be available.
We are not interested in all those. See? Cooperate with the court, both of you.
Yes.
Your trial court fighting method will not work in this case.
Yes.
But take note of. We are only going by a logical examination of the entire. We want to see sale deed 1800.
Yes, Lord.
No, is it on record or?
No, it is in trial court's record. Exhibit 1. LCR पर अवलाय
And where is your written statement?
Lordship.
48.
Yes, Lordship. From kindly peruse from paragraph 4. Paragraph kindly 11 also. Paragraph 11 also very much relevant. GMC holding number 428.
Land is identified by document, not the holding. Holding number is a number given by the municipality for construction. That may keep on changing from time.
They did not deny my holding number.
We are not interested to know holding number. We are interested to know which land he is claiming for and what land you are in occupation. Can you read, Mr. Roy?
Yes, I can read.
Please read the
Yes.
Read the top of it.
Yes, Lordship.
You should be able to read.
Barabar Shri Durboli.
Not the whole, only the top.
Yes. Topsil, yes. Topsil Lordship, at the last page, Guwahati Sub-Registry Elakadhin, Guwahati Thanar Antargat.
Where are you reading? Guwahati. Sub-registry.
Sub-Registry Elakadhin, Guwahati Thanar Antargat, Beltala Moja Fatasil, Ambari Gaon, Heraz Miadi number 25 Patanu, the Dag number Ek Kotha, Ek Lesa, Ek Kotha, Ek Lesa.
Posis number, Heraz Miadi Patal. 20 number Dagor. Iman
Mati Ek Kotha, Ek Lesa.
Kotha Iman Mati. So this is the land purchased by the predecessor of the plaintiff. The house number is holding number 2427. So you want a declaration in respect of this land. Now, what is your schedule of your land?
We are possessing, we are not exactly mentioned as schedule. Your Honor will find
have
that
to mention, otherwise you are not denied.
my plot of land is government plot of land.
Mr. Ali, you cannot create a confusion and deny somebody else's land. You make it very specific. Either you say the scheduled land of the plain, it is my land. Or you say my land is something different. Then we'll examine whether your different land and the scheduled land are one and the same. If it is not one and the same, if your entitlement is to some other land, but you are in occupation of the scheduled land, you have to go. You cannot, by taking recourse to that I am having entitlement over some other land, you cannot occupy his land. Is it not the law?
Yes.
So first, now you tell us what is the schedule of the land in under your occupation.
Paragraph 4, Your Honor. As per
4 of the
WS.
WS. Yes.
As well as paragraph 11 of my WS.
So you don't even know your pata number.
No, pata in government land, no pata.
Then
only Dag.
Then the petitioner's land is not a government land because they have
Their pata land. Their land is pata land, Your Honor.
So now it possibly is a case of identification of land.
That is also there.
Has the court identified the land?
No.
You are claiming some government land.
Yes.
I am in occupation of government land.
Yes.
He is saying Pata 25 tag number is my land. So no one knows which is the disputed land. Disputed land is your government land or disputed land is his Pata 25 land. No one knows. Is there not a requirement to adjudicate this issue?
Yes, after denial, Your Honor, that burden as per section 101 of Evidence Act, that burden lies on plaintiff.
No, his burden he has discharged. His burden he has already discharged that this is my land.
Your Honor.
So now, Mr. Ali, to counter that what he has established, it is now your burden to show that I am entitled to and entitled as well as occupying this particular land. Then the court will examine whether it is the same plot of land or it's a different plot of land. If it is the same plot of land, we'll again determine as to who is entitled to the land. Whether that land under your occupation is government land or your land under occupation is the Pata land. If necessary, we will take help of the revenue department to make an assessment. But your rhetorics will not help you.
But Lordship, as per section 34 of Specific Relief Act, for seeking a declaratory decree, there must be apprehension.
Ali,
there must be
Mr.
apprehension.
Ali,
Yes.
all civil lawyers are so enthusiastic about technicalities that ultimately you miss out the original. First, go to the fact of the case. Then we'll go to the law. Suppose you have entitled over a government land, having duct number 20. You don't know the patta number because there is no patta number. He is entitled to patta land of 25, duct number 20. If you are actually physically occupying that patta land, believing that it is a government land, you'll have to go. So somebody will have to find out whether the land under your occupation is the patta land or it is a government land.
That's true, Lordship. But
it is not only true, that is the issue to be decided.
Lordship,
And
for
Mr. Ali, we please desist from expressing the expression that is true. Don't do it. You are not in a debate before the court. You are
Yes.
here to
Sorry.
submission, legal submissions. And neither we are interested in your comment or your certificate, whether the court is true or false. And the basic artistry of an advocate. Your approach more appears to be an aggressive nature, which possibly Mr. Roy must be knowing in the trial court is highly prevalent. The louder the voice you make, the stronger is the argument. It will not hold good for you here.
Sorry.
No logic. Think logically. Just a picture. If you're right, we'll discuss the but we cannot allow you to bulldoze your way, but just by raising and getting a little more aggressive. And where is the finding of the trial court whether the disputed land is the government land or the disputed land is the land of patta number 25? Where is the finding? I think that ought to have been the first issue.
Yeah, nothing has been, Lordship, it's so cryptic.
After hearing the plaintiff and reading the plaintiff, and after hearing Mr. Radi and reading the statement, it appears your case is mild and is patta 25.
Lordship,
This case is government land patta distinct.
Lordship, under the CPT, the duty is casted upon the court
That is
to
why
find out and to appoint a main commissioner just to measure the land of the both parties.
One of the issues ought to have been whether the disputed land is covered by patta 25 or the disputed land is a government land.
Yes.
Only then you can decide this issue.
That is was not.
See, I am keeping on making a statement that I am the owner of a red pen. You are making a statement that I am the owner of a blue pen. But none of us know whether the pencil in dispute is a blue or red. Don't you think that has to be decided first? If the pencil in dispute is blue and he establishes he is the owner of a blue pencil, it is his pencil. And it is not your pencil because your claim is I am the owner of a red pencil. If the pencil in dispute is a red pencil, same goes with the other side.
Yes.
But now we don't know whether the land in dispute is the patta land or it's a government land. And there's no point in burdening ourselves in going into the bulk of this record, etc., unless the core issue had been gone into by somebody.
Some findings are there in appellate court judgment at page 21, page number 21.
21.
Yes.
21, no?
21, serially 21, internal page 7.
What is there? Please read. Which paragraph?
Internal page 7.
7, running 21.
On the other hand, the defendant plea is that he is possessing 10 acres of land by constructing Thatcher's house, being holding number 428, which is assessed by GMC in the name of Rameshwar Ghosh of ward number 11 old 20 new. Exhibit A and B are revenue paying receipt for the holding number 428.
Mr. Ali, this is the you expressed this view a little time back. land is always identified by tag number and patta number. Or government land or whatever it is. Land is never identified by holding number. Holding number is respect to the premises standing on a land. Anybody can give any holding number to any premise.
That is only for the purpose of collecting tax.
That has no relevance. So we know he is taking a claim to some land, which he described to be Pata 25 taxation. You are taking claim over another plot of land, another land, or maybe same land, which is government land. So, first thing the court should know as to which is the disputed land. If the disputed land is the Pata land, your stand that you are occupying government land will not entitle you to a right over the Pata land. If the land is a government land, then it will not entitle them any right over a government land because they have entitled over a Pata land. First, identify the land. This must have been the first issue by the trial court. Reading paragraph 3, 4, 5 of the plain and reading your paragraph 4 of your written statement, that must have been the first issue to be framed. Without framing the appropriate issue, if you go on proceeding with bulk and bulk of documents, what kind of a conclusion can we arrive at?
Your Lordship, allow me to issues framed by the learned trial court, Your Honor. Two vital issues are there, that is regarding right title interest of the plaintiff.
So, appellate court can always reframe an issue in sentence if it is not appropriate.
Lordship, learned appellate court decided only two issues. Though the learned trial court has framed Lordship as many as
here, issue number 4, whether the defendant are illegal possession of the Schedule B land and house.
Schedule
B land.
This is not an issue. Issue is, you please read the plain.
B is part of A.
Which page is the plain? Which page is the plain? Is that right?
Plain Lordship. Page 25.
You read paragraph 4 and 5 together.
Yes.
As well as schedule A to D. Okay. Then this is my land. My predecessor had purchased it from the authority, and it has a definite description with the schedule to the where examine the sale. It's on record. Sale did say is KP Pata 25, tag number 20, with the north-south boundary. So this is that. Now you read your written statement. The defendant for one owns and possesses plot of land measuring 10 is covered by tag number 20. Then land in question is the government. Okay. So the first issue ought to have been, as both were taking claim to different land, which is the disputed land in the on issue. The example I gave you, you established every document to show you are owner of a blue pen. He establishes every document I am the owner of a red pen. And we don't know whether the disputed pencil is red or blue. Is it logically possible to deliver a judgment whether you are the owner or he is the owner? Until and unless we know the disputed pencil is a red pencil or a blue pencil. What you are arguing is, I have established my. Yes, you have established to the extent of government land. He is claiming, yes, I have also established it pertaining to Pata 25, that way. And we don't know which is the disputed land. And here again, the trial court deviated from what is required is the issue framed is Schedule B land. Issue framed ought to have been Schedule A land. Because Schedule B land is only the description of a house.
Schedule, in respect of schedule.
Just now you read out Schedule. When did you read out?
In respect of schedule, issue number 3 was
Page number,
same, Lordship.
page number 10.
Page number 10. Get it. Yeah.
Page number 10 is correct.
Yeah. Page number 10 clear. Judgment.
Page number 10.
Page number 10 is not a you're reading.
Lordship,
Page number 10 is some paragraph 9 of some memo.
Lordship, regular page, Lordship will find at page 70.
You have to refer pages number as per the code record, not as per the document you have. Before starting hearing, you have to take note of.
Annexer 7.
Yes, Mr. Roy. Where is the issue?
Issue, yeah.
Page number.
75. Page number 70.
Page Lordship 70
70.
of the memo. And Lordship, if your Lordship permit me, I would like to point out vital issue.
Later on. First, let us see.
Okay.
Which is maintainable for the back owner and possessor of a schedule land.
Yes, that's right.
What is the finding on this issue number 3?
Issue number 3, Lordship, by the
Page number
Learned
page
trial court.
71. Decision is at
Issue number 3, Lordship, page 71.
70.
Page 71. My title has been admitted in the WF Lordship. That has not been denied. Our ASA.
Yes, Mr. Roy. The original of this certificate copy had been verified. So
Yes,
what
yes.
is there
Proved in original.
Huh?
Proved in original.
Proved in original.
Lordship, that is admitted fact. They have not denied in their WA. Admitted fact need not be proved.
Mr. Roy, you were
Sorry.
slowly coming to it. No? Now, Mr. Ali, come to page 70. Yes, read the first paragraph.
The learned counsel of the defendant submitted that the execution of sale deed exhibit 1 is not proved as per mandate of section 67 of the
So this
Indian.
is your submission.
Yes.
Now please read section 67 of the evidence.
Proof of signature and handwriting of person
Proof of
alleged to have.
signature. If a document is alleged to be signed or to have been written wholly on party by any person, we have not made any such allegation that it is written wholly or party by some person. So section 67 is not applicable. What is applicable is read
68.
But
actually 68.
No. Read section 76.
Certified copies of
Certified
public.
copies of public document.
Right.
What has been produced before the court is a certified copy of a public document. And read 79. Presumption as to genuineness of certified copy. So on this ground alone, the determination by the trial court is not sustainable, because trial court had accepted your submission up to the penultimate paragraph of that page 72. Submission of the original statement does not prove its execution when the defendant denied the right that the interest over the suit man. So it is the bounden duty of the plaintiff to prove the execution of the statement. You don't need it.
That is as per section 68. Section
No, you don't need it.
Section
No, you don't need it, because a certified copy has been denied.
No, Lordship, original, sorry.
Certified copy of the original.
Original sale deed was exhibited.
Original was exhibited.
Yeah, yes.
Certified copy.
Yes. No, it is.
Original is to prove as per section 68.
I had flagged the trial court correct.
Why is required?
Witness by calling vendor, because they also did not their implement their vendor, which was executed.
Even if the original is projected, it's a registered document.
Yeah.
Registered document evidence is governed by some other provision.
Yes, public document. It is a public document.
Public document. Moment is a public document.
They did not also implement that vendor to prove that
They
the
did
not required.
They did not prove. They did not prove. Unless there is a counter suit filed by the defendant, we are challenging this validity of this statement. Burden of proof is not to that extent. Take up the evidence. 106 is not applicable here.
In reply to paragraph 328, Your Honor, to some extent, there is a statement regarding denial of title of the plaintiff.
Your denial, you have to prove. If moment you deny, burden is on you to prove it, not only take a stand. And ultimately, the court issue is to remain as to which is the disputed land. He is claiming, and which is the disputed land under your occupation. Identity of the land. No one is identified. Think over it. We'll take up tomorrow. But it's not. Let's take it.
Day after tomorrow, Lordship. Tomorrow, some matters are fixed.
No, day after
Learned
tomorrow,
trial
Lordship.
court.
Tomorrow. So we can't retain so much of.
Old, very old case, Lord.
No, not old. Why should I take the burden of retaining everything for 2 days in my mind?
The problem.
Why don't we do that, John? You said today, we're deciding today. If you don't want, we do it today.
Today,
See, after hearing you for almost 1.5 hours, lot of things have come to my mind.
Yes, yes.
Lot of things. You can't expect me to retain everything, have a good night's sleep, come back again tomorrow for other matters, retain it again for one more day, then we remain fresh for you day after tomorrow. We are only giving you one opportunity because certain views appear to be, certain preliminary views form appears to be against. So therefore, we are giving you the opportunity to prepare it.
Some matter has already been fixed at
Doesn't matter.
trial court as well.
That doesn't. That means lawyer who is 100 times more busy than you will ask for a date after 3 years. Why? I have so many matters to do. If you go to Harish Salve, possibly he'll ask a date after 10 years. If you give a long list of matters, he is there. He does. It's just how you do it, your problem. And in which court?
RERA at Thanapara court as well as trial court.
Oh, RERA Khanapara is a court of a higher domain than
tribunal, Lordship,
And,
nothing else.
So,
trial court.
so the trial court is a court above the high court.
No, that
What are you saying? Firstly, you'll have to answer is whether 67 of the Evidence Act is applicable, because this is the registered document. Once it is a registered document, possibly which section is available, applicable? Evidence Act?
67, I think.
67 is not applicable.
No,
for
public document.
the public document. Can I take a look at the original?
Yes.
What is-
Yes.
No, not those photocopies. Actual original.
Original is lying with the client. Tomorrow I can put it.
I just want to see what is it. Whether
I
it's
am
a
having the
copy.
Xerox copy of the original.
So let us see what. What is this?
Exhibit A.
No, not court return.
Seal
Ah.
seal of the registrar, sub-registrar.
Register.
See, that is,
What is the legal implication of this?
as per Registration Act, Lordship, it is to be put there that the
No.
proof of presentation for registration.
So this is certified.
No, this is original thing. Put over the original thing.
And what is the legal implication of a registered document? Is it required to
Registered
be-
document,
is it
Lordship,
required-
until and unless
Yes,
it is
yes.
challenged by some party, Lordship.
Not
It
required
is
to be
required to
proved,
be-
I think.
Yes.
No, Lordship, it is required to be.
Under which provision?
Actually, exactly 68
No. 68 is
of
not
evidence.
with respect of registered document.
Execution must be proved, Your Honor, by calling attesting witness. Proof, not
No, sorry.
proof of the contents, Lordship, by calling
No,
witness.
it is not proof of execution of required by law to be. So
At least
68
one attesting
68 is
witness.
applicable
Yeah.
if the document is required to be attested in law.
Shall
The
deed is
registered
not
document is not required to be attested.
only give deed, Lordship, and will all these things attested.
Because registered document, it becomes a public document under section 74. Public records kept in any state or private document. Suppose there is a hundi, that a promissory note. It's not registered anywhere. That there 68 will be applied. Suppose Mr. Roy said that he is there, owes you 10,000 rupees, gives you one note, and you claim in a court of law that 10,000. Then the question of where to prove it. But registered document. Registered.
How many documents are this? What is it? Xerox copy, original.
Feeling the burden of
Actually, this is the second appellate court. So
Maybe
some restrictions are there to consider additional
You
evidence.
don't have to teach the court the restriction of second.
Yes, sir. As law.
This will be a substantial question of law, very much in the domain of the state.
अरे हमारे ये documented content इन बुझिए ऊपर में कि
Then let's kindly remind the matter to issue frame
What
proper
we are
issue,
thinking, because
frame proper issue and to adjudicate the
the whole
case.
issue is not decided. And my example of blue and red pencil I have given conveys the clear meaning.
I may be given
He is
opportunity
establishing he is on a red pencil, you are a blue pencil, and we don't know whether the disputed pencil is blue or red.
I may be given liberty to cross-examine all aspects.
Complete. Definitely. When the issue is not
definitely,
framed,
definitely.
when the issue is not framed properly, then of course complete liberty. And we wait it tomorrow. Think over overnight if you have something different.
Order may be passed, Your Honor. I have
Today
no
itself.
objection. I have no objection. Sixty-one to some extent applicable, or evidence. Document evidence, proof and contents of document. That part is also, although both the court below did not consider it.
Otherwise, why should be there a requirement to register?
Section
Could have done away with the registration process.
Kindly
If
please.
everything has to be proved.
Section 61 of evidence.
61.
It may be primary or secondary, but contents must be present.
Once a document is exhibited,
No,
all content
Mr.
deemed to
Ali, there is a difference between proving the contents of a document and proving the execution of a document. 61 relates to content.
Yes, sir.
And moment the primary document is placed before the court, the contents are proved. And what you are assailing is the execution of the document. Execution is not governed by 60. Execution is possibly governed by the law of registration.
yes. And the Registration Act provides lordship, once a document is registered lordship, it will be deemed to be genuine until and unless.
Which provision? That's what I'm trying to.
Not genuine.
Which section?
Registration Act. Sorry, my lord.
Principle, I am also aware, but I
Yeah.
have to look at where it is there.
Now, there is apex for judgment also.
Producer just more or
Yeah.
he did not even pass the order, but in this particular line. And if you want to say something more, please come tomorrow.
Yeah. It is not possible for me, then my colleague will.
Anybody. But okay. Where I defer the hearing. And produce the just.
Okay.
Where the registered document is not required. Execution is not required.